Okay, welcome everybody. March 26th. I can't talk tonight apparently. March 26th, this Thursday. My name is Randy Shannon. I'm your host and moderator. And I was reminded earlier tonight to remind everybody, mainly just the three-letter agencies, the alphabet soup, that the guests that we have on the calls, we believe in our First Amendment rights. We believe that it's our birthright to talk and to speak and to share information. And when we have guests on here, it doesn't necessarily mean that we are all on the same thought track. But what I do believe is that we all should share our information, and then people can go down their different paths of what they want to work on with their cases, what they believe in, and what they believe to be true and right. So with that, there's the disclaimer thrown out there. I'm really excited to have you guys all on the call tonight. We do have a packed call. We may or may not get Dr. Livingston on here. I don't know if he has forgotten us, but that's okay. I just want to make sure that you guys know that we have a packed call. We've got a full lineup. And even if he joins us a little bit later, she'll be okay. It is 8:04, and if Dave is ready, I do want to start off with you. If you want to talk about your case, just give the brief rundown because we have a lot of new people on the call tonight. And if you would tell us what happened in your case this week. And I want to discuss your case. And I don't know if Steve has joined us just yet, but I want to have everybody's input on what you guys would do or what you think Dave should do with his case. Dave, are you ready to go? You are unmuted.
All right, I apologize. I thought I was
That's
unmuted.
Okay, there you go.
Yeah, I'm going to just pop all this off the top of my head. I do have some notes in the computer someplace I was going to follow, but that's no big deal because I've got it ingrained in my brain what's going on here. For those that don't know what happened, I was involved in a simple property damage vehicle accident with a vehicle sideswiping me back in November. The cop made an assumption I was going someplace I wasn't. I let him know he's not going to put words in my mouth. It's just not going to happen. An hour later, after the accident so-called investigation was done, I was cited for careless driving, which is a misdemeanor in Colorado. It's a criminal offense. And I was arraigned January 29th in a court, and I've never been arraigned in my life for anything. So I've had a few people go to court with me who were very, very supportive and who they are as far as what we all are, to stand on our unalienable rights, which I didn't handle myself in court properly other than continually object and tell the judge does not have jurisdiction. The judge stole it from me anyways. I submitted all my evidence on July 29th. I had a motions hearing. Oh, I apologize. Let me stay on point here. The judge told me I'm facing a year in jail and $2,600 in fines, or I can take door number 2 with the prosecuting attorney who's going to reduce it down to faulty vehicle for 2 points and just pay some fines, and I refused. I paid a $25 fee for a jury trial. I got a stamped receipt for it, and I had to go back for a motions hearing on February 24th. During that motions hearing, I again told the judge to dismiss this charge. She wouldn't. The prosecuting attorney put a motion in to reduce the charge from a criminal offense to a traffic violation of driving in 2 lanes. And I again refused. They said it's $400 in fines. I refused to accept that offer.
Hi, Dr. Livingston.
Dr.
All right,
Livingston
excellent.
online.
We'll get started.
Hi, Dave. Hi, sorry for the delay. There's an old saying that somebody made up, says that you never know what time it is in someone else's life, and I think that was it today for me. All right. So I just have a few minutes. Greetings to all, and if you'll allow me to go ahead and present what I have. I've got 2 other conferences, one behind the other, I still have to do this evening, but I'll try to get right to it. Okay?
Okay, Dave, do you want to just hold for just a
Yeah, I'll
minute?
hold for that. And Dr. Livingston, I know some of your work. I'm in Denver, and I was one of the individuals who went down to file the extraordinary lawsuit back a few years ago.
Oh, were you? Okay, good. So you know the depth of it. You know what happened the first to Mr. Hall, I guess it was.
Yes, that was his name. Yeah, I know what happened. Yeah, I do.
Yeah,
Okay.
Anyway, so we'll go over that later. Anyway, so okay.
What we definitely want you to get into tonight, this is Randy, is we want you to talk about breach of warranty because a lot of people on the call, are interested in 42s, and we want to know why breach of warranty is better. And folks, for those that just heard him pop on, that is Dr. Dale Livingston, and he's a professor of law. We're glad to have you. Welcome, sir. You have the floor.
Okay. We actually started with something along this line a few years back, but we got into going after the federal, and we actually had all of the judges in the district court recused. They recused themselves one after the other, and finally they brought in a judge out of Denver by the name of Kane, K-A-N-E. And he was an old judge getting ready to retire, and they're always the most dangerous kind because they're not afraid to do anything because you can't do much to them, they're already ready to retire, so, they don't really care so much. So Kane came into it and just kind of wouldn't recuse himself, but he should have because we had the same issues involving the United States government, and he was no different. Nevertheless, the issue here is something that came to my attention, like I said, back then, and I put together a lawsuit that's kind of should be usable by almost anyone, in any state. Okay, it's called an Article 4, Section 4, breach of guarantee by guarantor. Okay, now. I'm fairly certain that it was James Madison that wrote this piece. It was a brilliant piece. Strangely enough, however, in over 200 years, somehow the legal profession has missed actually taking this concept and running with it. Okay, that is especially in sight of the fact that breach of warranties, lawsuits are just as common, a dime a dozen practically. You got a product of some kind, there's a warranty on it, and the manufacturer does something that breaches the warranty, and so you sue the warrantor for the consideration that was guaranteed against the breach. And so breach of warranties are just, very, very common. In all these years, however, for some reason, there doesn't appear to be a case where the United States, now you understand the Article 4, Section 4, it is the United States, all three branches that are actually online to force the states to comply with what's known as a Republican form of government, okay? Whenever you bring that issue to the front to define what kind of government that is, it is defined not so much by what it is, rather than more by what it is not. Okay? For example, we would state that a Republican form of government is a government of law. Okay, it's a government of law. It's not a government of rules or these things. So we get into the issue then. What is it not? And that gets into these kinds of things. It is not a government of policy. Policy would extend to things like politics and political parties and police. These would be unlawful in a Republican form of government. Okay, it's also not things like theories and beliefs and opinions and practices and impressions, upbringings, taste. There's about 20 to 30 different kinds of things that you identify that this kind of government is not. Okay, we never got to have this kind of government because they brought in everything else but what they're supposed to. Rulers would be judges. Okay, and at some point, on probably another occasion, if you'd like, there's a video out there or an audio out there where I was interviewed by some radio pros from New York, and they recorded the whole thing. It's online now. It's on, I don't know, YouTube or something. I'm not sure, but Randy's heard it. The other people have. It is actually something that demonstrates the concept. It's kind of a controversial thing where I came forward and I said, in a criminal case, no one in this country, state or federal, doesn't matter, has the right to a trial by jury. Okay, no one has the right to a trial by jury. In a criminal case, of course, most people freak when they hear that, but when they hear the entire story, then they don't, because it's not something that's actually favorable to judges, even though on the surface it sounds like it is. Okay? So, a Republican form, a breach of guarantee by guarantor. There's never really been a lawsuit of any magnitude or whatever that has addressed this issue. What's nice about it is that in terms of the question of jurisdiction, okay, the jurisdiction in this kind of a lawsuit is what we call plenary. Plenary means full. The jurisdiction is full. Okay, the jurisdiction is actually built into the law itself, the constitutional law, so we don't have to go looking for something that we like we would if we were doing a Title 42 or something like that. Now, I've done a lot of Title 42 lawsuits over my years, and you always have to struggle, and you have to hang on just a second. Hang on just a second, folks. Don't go away, please.
You got it. By the way, if you guys look in the email I sent out, I believe the interview he's talking about is the one that I put at the bottom of the email. So you do have it. It's about 2 hours long. And it does do a very, very good breakdown of what he's talking about. Not necessarily the breach of warranty, but the beginnings and the Constitution and the amendments that he's talking about. So we'll give him here just a second. By the way, if there's anybody you need to get on the call tonight that you think needs to hear what's going on, and Dave, we'll pick you back up
Hello?
after. Yes, go ahead.
Okay, sorry about that. I didn't expect that. Anyway, bottom line is that not only is the jurisdiction already there, it's built in, breach of guarantee by guarantor. All three branches of the U.S. government are responsible for this, okay? And just as in any case where you're suing for a breach of a guarantee or a warranty, there is no immunity for anyone. You do not sue the state. See, this is the key. You don't sue the state. They're a party to it, yes. They're the damaging party. They're the ones that's violating your rights under Article 4 of Section 4 at the state level. The state is doing this. The federal, quite frankly, is doing it too. But you don't sue them for what they're doing so much as you sue the state for what it's doing, okay? So the federal, no immunity. The state, as long as you're doing it in the right direction, also no immunity, okay? They're the subject party, but you don't make them the defendant, okay? You make the United States the defendant. That's it, okay? By doing it that way, no one has immunity from lawsuits. Where have you ever seen a case that's that actually easy, okay? So long as we lay it out in the proper order, then there is a client of mine, a gentleman there in Florida. He's the one that introduced me to Randy here. We're about to launch a lawsuit because what happens in his case, the state created a kind of a court. It's not really a court, but they pretend it to be. Okay? They violated the separation of powers required by a Republican form of government. Now, I want you to be sure to understand that, and don't confuse this with the party. Technically, believe it or not, political parties are actually unconstitutional. You know that? Political parties and politicians and politics and police departments are all illegal. They're all unconstitutional, every one of them. Okay? Try to imagine that. So, to me, the whole issue, this whole thing was somehow covered up. I think maybe it was inspired, maybe by heaven or something, because how do you go over 200 years with no one seeing and recognizing the obvious? There's a guarantee. Who's the guarantee? Who's the guarantor? It's the United States. It says so. How can that easy a knowledge be missed by so many in the legal profession? I know most attorneys are as dumb as bags of rocks. They really are. And a lot of law professors out there, I'm ashamed that they behold the same occupation. Because somehow they've missed it. There's a lot of things they've missed, and I'll share some of those with you at some point here. You'll learn about what existed before the Civil Rights Act of 1866, raising a very serious question. What did attorneys or what did legal minds do before there was a 1866 Civil Rights Act, or what's now called the Title 42? What existed before that time? To take a case to the United States Supreme Court. How did that work? I'll tell you, when I called a friend of mine who was an attorney at bar and a good close friend, I asked him, I said, what do you know what existed? And he didn't know. Okay, that's because the actual process that was involved at one time in this country hasn't been used in over 100 years. Okay? That's why. So anyway, we have this lawsuit. We're going to be bringing it. We may incorporate the pre-1866 approach to establish our right as a fundamental right to do this because of the fact that there was a way provided. There was a way provided in the Constitution, and like I said, it hasn't been used in over 100 years. Okay? So this lawsuit, if you know some people, okay, in this one client's case there, they came after him. They created an alleged court, and they fined him. They did all the things that a court would do. This is known as it's a separation of powers violation. Okay, there's supposed to be three different, very separate divisions of government in the Republican form of government. A number of states, it's not just Florida, a number of states have gotten into this. They create something in the executive branch that's pretending that it can act without due process of law in the as though it's part of the judicial branch. It's not part of the judicial branch. This is an offense. Another term for it is something that I came up with. I was the first professor to come up with the term in a federal case in 2007. In this case, I don't know how many of you know what recusing a judge is, and especially recusing a federal judge. I'm the only professor of law that actually had two United States district courts. We were suing the judges in both courts, all the judges. I'm the only one that ever had all judges, both courts, involuntarily recused by the order of their chief judges. Okay? That's never happened. To get one of them recused is not easy. To get a whole court recused, not done. To have two courts recused is out of this world. Okay?
Do you want to say the name of that case?
Do what now?
Do you want to say the name of that case?
Well, it was Stephen Muffleman versus the United States. Yeah.
You want to spell his last name? Stephen what?
Muffleman, I think it is. Muffleman.
Okay.
Stephen Muffleman. He was charged falsely in Massachusetts. He was living in Florida at the time when he became a client. He was charged very fraudulently with mail fraud. Okay. I came back and showed that the concept of mail fraud by the United States is of itself a fraud. Mail fraud, okay? We brought a lot of issues before the United States, including seated treason, lack of constructive subject matter jurisdiction, and another little thing called de facto nation, and so forth. We moved the case. We went into Massachusetts against the judges there. On May the 3rd of 2007, Chief Judge Mark Wolf issued an order recusing all of the judges. Okay, we filed the case on February the 16th of 2007. The U.S. attorneys argued that Chief Judge Wolf moved too fast in recusing all the judges. Okay, when that happened, we moved the case. They moved the case first to Rhode Island. When they moved the case to Rhode Island, we moved our cases over there as well. So Chief Judge Smith, I don't remember his first name, Smith he also ended up recusing all the judges in Rhode Island. Okay, that's because the evidence we have against the United States is very serious. Very, very serious and very factual and so forth. So that's what happened in that case. Okay? That's what happened.
How'd they move it to another state?
The government went to the chief judge of the First Circuit Court of Appeals and got permission to move it. Okay, that's how they did it. I didn't know how they moved it. I thought they got some dumb clerk to sign off on it. So I just went. We got an order from the judge, the chief judge in Rhode Island. When he sent us a notice, he said, "It's been moved over here, and don't reply to this case." Well, what did I do? I replied to that case. I accepted his order and went ahead and extended the lawsuit to all the judges in Rhode Island because it was the same issue. The same evidence against the United States. And when he got the evidence the hard way, then he had no choice. Okay, so there's a lot of things. I'm actually breaking ground in a lot of areas, and we'll talk about this 100 years thing that's the way it used to be and so forth. Also, the issue of, it's really, in my opinion, it's probably the biggest daily fraud in the United States. The corruption, the belief that we have this right to trial by jury when that isn't the truth at all. Okay, no one in a state or federal case, in a criminal case, has the right to a trial by jury. Okay, when you learn the truth about that, though, you won't be unhappy at all. Okay, trust me, you won't. Okay, and so we're going to move this country into the right directions. I think, and just my opinion, that maybe the Lord above kind of had this issue about the guarantee all this time, just waiting for the right time. The right time to bring an action amongst all the states, the people, bringing lawsuits, even to bringing lawsuits that are nothing less than, this is just a heavy issue because we're going to go to them and we're going to establish that there is no immunity. How do you get immunity when you're the guarantor? How is there an immunity possible if you are the guarantor? There is none. So the United States, the guarantor won't have any immunity. Neither will the state that we are accusing indirectly. We're giving this as a sort of similar to the issue so that we establish that they did it, they've done this, yes, but you're the ones that let them get away with it. Okay, that's how it works. The United States is responsible. They're supposed to have guaranteed it. They haven't. They've been letting it happen. So now we need it to stop. Okay?
Okay.
So,
one of the things I wanted you to touch on, and I know you don't have time to do the entire breakdown, but the case that you were just talking about, New York to Rhode Island and back, is that the case where you put the demand in for a trial by jury without a judge?
That's right. First
Okay.
one I did was in 1997. I believe it was 97. Yeah, it was. First case that I did that and demanded trial by jury without a judge, and the judge totally freaked. When we went into the arraignment and we pled not guilty, he said, I don't understand why you're pleading not guilty. You either have this particular thing or you don't, okay? When we got to the actual case, the trial, he totally reversed himself and said the prosecutor didn't make his case, you know, because he didn't want the truth to go uphill. 4 days before that, as it was the day of trial, they rescheduled for us a pre-trial, okay? What was interesting about the pre-trial, it was scheduled for 4 o'clock that day. 4 o'clock happened to be the hour when the court closed. So they didn't want the public there. So both the hearing, the pre-trial, and the actual trial were scheduled at 4 o'clock when the court closed. Okay?
Okay.
So I've had this issue in a number of cases and states. I've had it before the 8th Circuit Court of Appeals. And because of that case, they actually changed the federal rules of criminal procedure to accommodate something in there just a couple of years later. Okay? So the issues are heavy. My knowledge of this issue is impeccable. When you learn the secrets behind the whole thing, you'll know that the framers were trying to do something for us. They really didn't want judges in our faces. They really didn't. Okay? They didn't want the federal in our faces either. Okay? So we'll get into some of that, and you'll learn some things that are truly astonishing.
Well, to basically just kind of give everybody a taste of it, what you are alluding to here is when Madison was putting this together, he didn't want the judges in the courtroom. And
no.
Then I'm just going to go back with what you and I discussed. So he gave them cases from a penny to $20.
Yeah, that's the Seventh Amendment. Yeah.
Right. Okay.
The Seventh Amendment, that's a civil issue now. He put in there, they knew about inflation, and he put into it locked it in, really, the $20 point. Judges were locked in to $20 down to a penny, okay, meaning that they were to have the right. Oh, this is a right to be guarded, right? Okay, the right to any case that's from $20 down to a penny. You don't go into a court trying to take away their penny rights. They knew about inflation, so they knew prices were going to go up, costs were going to go up. They knew it. They knew that. So why would they lock in judges at not $28 and up? No, $20 down to a penny. The term preserved was just like the food. It was a term that meant that they were to have juries ready to take on the cases at any time, all day long. Juries were to control the courthouses, not judges. Okay? We got everything backwards.
Yeah, okay. And so your pleadings alone going in that say, I demand a trial by jury without a judge.
That's right. But you really know how to plead it. If you're going to do that, you really need to know how to lay it out. And I've done that. I'm doing that. Okay? It is how you lay it out. It's how you have to go in to show them exactly what the intent or the mindset of the framers were. Okay? They had lots of reason to hate judges and not trust them. Okay? But you have to still know how to plead the case. Okay? You can do it, but you'll do the thing. We had one guy in our trial. He was a friend of mine. He was a truck driver. He got, thereafter, he got a ticket as a truck driver for not keeping his logbook up, and that could have cost him his job. So he asked me if he could use my pleadings and so forth, so I said, sure, and I put them together for him. When I did that, he went to them and said he wanted a trial by jury without a judge, and they laughed at him until they got my pleadings. Then the laughing stopped. And he said, and he kind of waited for the trial, and the day before the trial, the judge faxed him a notice calling off the trial the next day. In the notice, the judge said, and I quote, "When the court figures out what the court's going to do, it'll let you know." Okay. They didn't do anything for over a year, and they finally gave the man his money back. So judges cannot explain how they legally exist in these cases. Not really. Not competently. There's too many things that go against them, and you'll learn about all that. If you haven't already, you'll learn about it. Okay? So, anyway.
What would you do in a case where a guy gets potentially or maybe thrown into jail or car impounded, or a guy like Dave was talking, he was in a car wreck, somebody hit him, the cop didn't like his attitude, so he made him at fault. And they've stressed him out for 5 months of his life. He puts in incredible pleadings, and then the judge says, we're not going to let you have a trial by jury, and they denied everything. And so then he puts all these pleadings in, and then he gets a letter in the mail that says case dismissed. But they wasted 5 years of his life, stressed him out, made him spend all kinds of money to fight this. What would you recommend?
Well, the impounding process is already an illegal process. Okay, it's an illegal process. Okay. If you got into the reality, you start saying, okay, so now we know it's racketeering. We know what they're doing. It's racketeering. But let's get real. Let's ask the right questions. If we do that, things tend to change. For example, what were they going to do with the vehicle that they impounded? Okay. There's only one legal right that they have to do anything. And that is they don't have the right to put it into an impound. An impound is not a legal process. There's a thing that they do with all things supposedly made part of a crime, and it's called an evidence room, right? So the only thing they really could do is put it into an evidence lot, not an impound lot, an evidence lot. And there's only two purposes that they could have for doing that. If they're going to call it evidence, then they mean on the day of the trial they have to pull that car into the courtroom. Do you think they're going to do that?
No.
No, of course not. The whole thing's a game. They're not. They could take pictures of whatever's in the car. If there's anything like that, they can gather. They can certify evidence. They can do that, but they're not interested in that. They're interested in selling the car, getting kickbacks. All right. So there's two scenarios. One is they pull the car into the courtroom, and they're not going to do that. The second one is they could adjourn the jury out to wherever the car is in the evidence lot, not the impound, in order to examine the evidence there, and they don't do that either. So the moment you eliminate both of those issues as possibilities, the only thing you come up with is racketeering. Okay? It's a totally illegal process. It's always been that. I'll get deeper into that maybe the next time you want me to, okay?
Okay.
Because it's happening to a lot of people.
Right, yeah. Does anybody have any questions real quick for Dr. Livingston?
Yes, I do. This is
Go
Wayne.
ahead.
Yeah, this is Wayne. It's my understanding when you plead, be it guilty, not guilty, when you make any kind of a pleading, you are actually subjecting yourself to their jurisdiction.
Yeah, you are, and they don't have the right to ask you any of those questions. That's where, when we did the 8th Circuit Court of Appeals issue, and I raised those issues with them, then the thing that happened next was we had this thing where now if you try to plead nothing, the magistrate who will arraign you they put it into the actual code that they will actually say that they will say that you they won't let you plead not guilty. If you say I refuse to plead not guilty because why? Because judges don't know whether or not you might be lying, and you might have this aversion towards lying, so that's where you're at, right?
Well, I don't know. What I'm kind of really puzzled about is it sounds to me like you're saying to voluntarily plead, and that to me sounds like you're voluntarily...
No. No.
Okay.
You don't, you're not, you can go in as a demandant. You can make a special appearance. That's not an issue.
Okay.
The issue is that you're demanding trial by jury because you don't have the right. Okay? Remember I told you, you don't have the right. It's
right
the
what?
jury that has the right. Okay? The jury has the right. Okay? The jury has the right.
I guess I'm really not comprehending your process here because
Okay.
the way I read the Constitution, I have a right to demand trial by jury wherein I am part of the process I am part of the party.
That's right. You have the right to demand it, but the only reason you're demanding it to begin with is because they're not doing it right to begin with, okay?
Okay.
They're not, if they were doing it right, you wouldn't have to demand it. It would be a foregoing issue. You would have trial by jury because no judge would be able to try to be in the case, all right?
Okay.
Can I follow that?
All right.
Okay.
That sounds good.
Okay.
So therefore, I guess the question I have is, why would you voluntarily put yourself into their jurisdiction by making any kind of a pleading?
Okay. Trust me. You can play the jurisdiction and all this. Okay. They don't have the right to ask you to plead guilty, Fifth Amendment. They don't have the right to ask you to plead not guilty, Ninth Amendment. Okay. But they have a little trick. And this is what I'll have to explain to you some other time. There's a trick involved in this. Okay. Something that they're doing that people are not aware of, and they get pulled in anyway, all right?
Okay.
Unless you understand certain concepts. For example, if I ask you what an assize is, what would you tell me?
I couldn't understand you.
What's an assize?
What's what? I can't understand.
What?
A-S-S-I-Z-E. What's an assize?
I'm sorry. It's just not coming through very clear. I can't understand what you're saying.
Okay, hold on. Wait, I'm going to mute you. What is an assign? Okay, go ahead, doctor.
It's spelled A-S-S-I-Z-E. I'm asking you what it is.
Okay, let me unmute him. Okay, go ahead.
Okay, you're asking assize as in what was it?
S-S-I-Z-E. What is it?
Well, I've never heard of it before, but I would assume it'd be something to do with the dimensions of something.
Nope, it's not.
Okay.
12
You're saying
jury.
S-I-Z-E?
A-S-S-I-Z-E.
Okay, go ahead and explain it.
It's a 12-man jury. It's a 12-man jury without a judge.
Okay.
I might be off.
That means this issue of juries without judges is not imagination, it's historical. Okay?
Okay.
What's embracery?
I've just never heard the term before. That's A.
Well, that's because I'm trained in law and you haven't been, not correctly anyway. Okay?
Okay.
So what's embracery?
Can you spell that again, please? A-C-C-I-Z-E?
No, A-S-S.
Okay, A-S-S-I-Z-E.
A-S-S-I-Z-E.
Okay, yeah. I have Black's Law here. I'll look it up.
Okay, yeah, you can. What's embracery?
We're moving on. Embracery. What's embracery?
I have it right here if you like.
Okay, what is embracery?
Assize, Black's 5th, page 110. An ancient species of court consisting of a certain number of men, usually 12, who were summoned together to try a dispute cause, performing the functions of a jury, except that they have a verdict from their own investigation and knowledge, not upon evidence.
That's Black's. No, that's Black's trying to put down the assize. They try to make it sound like these people are just kind of flying by the seat of their pants, and that's not true. Okay, you have to be careful when you read these definitions and understand that these legal dictionaries have an agenda of their own, okay? Trust me, they do, okay? So that's the assize. Now, the next question is what is embracery?
You got that one, Chris? I hear the page.
I didn't catch the word. If you were asking me a word, I didn't catch it. I'm apologizing. There are several definitions for that.
What is embracery?
Oh, I'm almost to it here.
Go ahead and tell us. Dr. Livingston.
Embracery is a crime that judges, sometimes prosecutors, but most often judges commit when they act so as to influence a jury either way. So tell me how in the courtroom would they not influence the jury just by being there?
Okay, that's making sense. Yeah, I have it, Blackfall, here now. The crime of attempting to influence a jury corruptly to one side or the other by promises, persuasions, entreaties, entitlements, and so on and so forth.
The public has never heard of embracery, but in our case, I threatened to charge the judge with embracery. Okay?
Okay.
Because it's a crime. They're not supposed to be in the courtrooms. Let's go to something else. Okay?
Go ahead, Doctor.
Let's go ahead to another issue.
Okay.
You're out of time here.
Another question? Next question.
Hello?
Yes, go ahead, Keith.
Yes.
What do you suppose the purpose of a jury is? The man who brought us trial by jury. The founder was Mr. Elbridge Gerry. He was the founder that brought us trial by jury at all. He did that on September the 12th, 1787, 5 days before they signed the Constitution. Okay? So he's the one that brought us trial by jury. What do you suppose, according to Mr. Gerry, the purpose of a jury is? What do you think it is? Anybody?
To stand up and hear argument.
Huh?
Right.
Excuse me, it's to stand up and hear argument.
Do you think that's the purpose of the jury, huh?
The jury is supposed to be a trial of facts and evidence.
You got it.
Right.
To hear argument and to know and understand and to disseminate the law.
Right. Well, according to Mr. Gerry, the man who brought us trial by jury, that's not the purpose of a jury.
The purpose of a jury is to try the law.
Yeah, well, that's not the reason it was brought into this country.
Well,
you want to know what it is?
Let's hear it.
Yes, go ahead.
Mr. Gerry, to guard against corrupt judges. And I've raised this issue with a lot of attorneys. So tell me, how does a jury know when the judge comes in the courtroom whether or not the judge is corrupt or not? Huh? How?
If his lips are moving?
How would you know?
That's good.
Okay. In fact, I raised this issue with a friend of mine who was a longtime member of the bar. He used to learn from me. I did learn from him, but he certainly learned a lot from me over the years because I was a teacher and I taught him. And I raised a question to him. I said, tell me, how would if a judge was allowed in the courtroom at the same time the jury was in there, how would they be able to guard against the corrupt judge? And he said they couldn't. He'd overrule them every time. Got it?
Mm-hmm.
They couldn't. If you allowed the judge to be in the courtroom with the jury, the judge would overrule the jury every time. Now, it isn't until we get into the thick of this, until we get into the reality of exactly how the Constitution was written to make it work, okay? It's then when we get into the actual reality of the pieces of the puzzle that we learn the truth, okay? Judges were never meant to be in courtrooms in criminal cases at all, and they also were not meant to be in civil cases. That was the courtesy of the Seventh Amendment, okay?
Is that why you do the assize?
The assize is what Okay, historically, the assize was actually supposed to be impaneled by the sheriff. And the reason for the sheriff is it's a public official. You don't do voir dire. The sheriff has their own process of determining who the members of the jury should be, the assize should be, okay? Of course, there's no political power in the assize, so the government, the legislatures and what have you have mistakenly allowed or provided for judges to be in formal cases, all right? They and the bar associations go back to back with each other, okay? That's what they do.
Okay, got a question.
I have to really go, guys.
Okay.
But if you want me back, get with Randy here and schedule me back, and I'll come forward and you'll learn lots of stuff.
Okay, this is just a name I need. You said the guy's name is Mr. Jerry?
Gerry. Mr. Jerry. If you go to Yale Law School, they have a project called the Avalon Project. It's been there for years.
Okay.
And it's got the Madison debates, as they call them. Okay.
Okay.
I call them the planning meetings. Okay. More legit to call them the planning meetings, because then you get into how the planning meetings do apply to the Constitution. Okay. More than these Federalists, the Federalist Papers, things like that. Those don't really apply. Okay.
All right. Interesting.
All right. Do you have time for one more question?
One more, and then I really got to go because I'm on the heels of another conference.
Okay, Keith, get your question, and I heard you ask.
Yes, I wanted to know if you're already into Title 42 action, can you switch it to the action of the breach of guarantee?
Yes. I've actually got a whole thing involving Title 42. It's an 1866. That's an 1866 law that was actually read the law upon which Title 42 is supposed to be grounded. It's an illegal law. The Title 42 is actually unconstitutional. Actually is. Okay. Madison gave us something better than 42. He gave us the guarantee. And as long as you understand what the guarantee was supposed to be, how it was supposed to work, you're good. Okay?
Yeah, how do we go about switching that? Can we get in contact with you?
You know, absolutely. You can go through Randy and so forth. Yeah, you can. And if you need me to work with you on something like that, I can do that.
All right, thank you.
Whoever
is interested
in
Dr.
getting a hold of
Livingston?
him, send me an
Yes,
email, and I'll put you guys in touch. Go ahead, sir.
This is Chris near Las Vegas, and you've been on my email list as a long-time exchanger of information, case law, and so on and so forth. And I really appreciate your friendship over these years, even via the Internet and coming on Randy's call tonight. Thank you so very much.
You bet, folks. Glad to be here to help. Okay?
Yes, thank
All
you
right,
from
we're
here, too.
definitely going to have you back. Thank you so much on behalf of everyone. And I'll call you this week or early next, and we'll get you scheduled again, okay?
All right. You betcha. Talk to you then.
All right. Thank
Bye-bye.
you. Bye-bye. Okay, so I wanted to let Dave finish. If you're not muted, Dave. Did you want to finish your case?
Sure.
Okay, go ahead.
Good evening, everyone, again. And Randy, I'd like Dr. information too.
Okay.
Going back to, I was in a car accident. A cop accused me of causing the accident. I let him know he's not going to put words in my mouth. An hour later, he cites me for careless driving. I go to court. I'm arraigned on the 29th. The judge told me I'm facing a year in jail, $2,650 in fines, 4 points on my license, or I can plead guilty to faulty vehicle, just pay a fine and 2 points, which I refused. On that day, I paid a fee for a jury trial, which I was entitled to because this was a criminal offense. I was charged with a criminal offense. There was a motion hearing on the 24th. At the hearing on the 29th, I submitted all my evidence. The judge told me she read my affidavit, and I'm making a lot of statements that could be used against me. Do I want to withdraw that document? I told her no. It's all proof. It's all fact and evidence. It's fact. It's true. When I went to the motions hearing on the 24th, she accepted the prosecuting attorney's motion to reduce it from a Class 2 to Class 3, which is no longer a criminal offense. Told me I'm getting my $25 back. I'm no longer entitled to a jury trial, and it's going to be reduced to being charged with driving in 2 lanes. Mind you, there's no witness, and it would be 3 points and $400 fines plus court costs. So I did not accept that either. It's set for a trial on August 6th. I had to file paperwork into the court by Monday, the 23rd, which is this past Monday. When I was at the court on the 24th, she returned me all my evidence, so she's not accepting it. When I refiled this Monday, all kinds of paperwork, and I refiled all my evidence all over again. I got a letter in the mail yesterday, a motion to dismiss by the prosecuting attorney, and the reason being because the out-of-state witness, who's not a witness, the other driver who hit me, he's from out of state and he's not going to come back to Colorado. They're saying their witness they won't be able to bring into Colorado, and they're asking. There's a motion for the 6th for me to accept their cause to dismiss. Well, first of all, they don't have a witness. It's he said, she said. Today I received a certified letter from my insurance company that's now notarized by a notary. The insurance company has determined I was not at fault of this accident. In fact, the other driver was. This is another piece of evidence. Now, I'm in a quandary, and I've talked to a few people. There's a few things going in my mind. Title 42, perfect situation, because they've all committed all types of violations against me. They've taken 5 months of my life away from me. They've taken my liberties from me. They denied me due process. They violated every one of my unalienable rights. The judge was acting as a lawyer behind the bench and being a judge and being a prosecutor. I mean, it's just ridiculous on what's going on, folks. When I was in that courtroom the first time around, there were 5 or 6 people in front of me. They would bring each one of these people up and say, well, the prosecuting attorney is willing to slap your hand with just a fine. Okay, thank you, bye, get sheared, and thank you very much. People were saying thank you for getting sheared and leaving the courtroom. I was facing a $100 fine. I stood my ground. I was not going to sell my soul out for some corruption to steal my money, my property, and who I am as an individual. And I stood up for myself, and all the paperwork I filed in the court, all of a sudden they get a letter in the mail yesterday from the prosecuting attorney. They want to dismiss my case because their witness from out of town is not going to show up. They don't have a witness, as I say. Now, when I looked at this document of this notice of service, the notice of service was certified by the prosecuting attorney. She put it in the mail on the 20th with the correct postage on the envelope. You know how certification of service is. Looking at the envelope, it was put in the mail the same day I filed my paperwork, which is the 23rd of March on Monday, stamped, metered the 23rd, yet they're certifying it was put in the mail on the 20th. More additional fraud. So I know I've talked to Mr. Curry, by the way, has been a great help in this case. He's your next speaker. He's given me some phenomenal information that I used. Chris, you're always a gem on all these calls. I appreciate all that you do. Randy coordinating all these different people getting on these calls. I sincerely appreciate everything she does. Everyone on this call gives something back to everyone when they open their mouth and stand up for their rights. What I'm trying to figure out here, because these calls are about finding remedy, and being able to find remedy with results. And we always talk about all these different remedies we're pursuing, and I'm reaching out to everyone. This, to me, looks like a slam dunk. The judge, by the way, refused me a jury trial. She returned my check. I put void right across it and not accepted, and put it back on the record again. So anyways, that's right now my case is basically I'm done with this. But again, they've taken 5 months of my life, 50, 60 hours a week in this office instead of working every day, but coming home till 11, 12 o'clock here, 10, 12, 15 hours on the weekends every day for 5 months just to fight this stupid corruption because I told a cop when he accused me of causing this accident, assuming I was going somewhere where I wasn't, and I told him he's not going to put words in my mouth. It's just not going to happen. An hour later, he cites me with this criminal charge with no, and as a filed affidavit with probable cause when he had zero cause.
So bottom line, Dave is one of our heroes. He's standing, and he has the ability here to say, oh, hell no, you're not going to dismiss this after everything you've done to my life, my wife's life, the stress, and everything that he's been going through, basically putting himself through law school. What on this call does anybody have to say about what his next step would be?
This is Bill. I got plenty.
Take a few minutes.
This is Bill from Colorado.
Hey, Bill.
And I believe Dave will be coming up here to the house, and I do have some stuff for him that I'd like to discuss.
Thanks, Bill.
Okay. Who else?
Well, this is Wayne. I guess I am really fond of Hartford's process of filing these criminal complaints, and I'm kind of torn between Hartford's lien process and Steve's BOEs. His BOEs, to me, sound like a simpler deal. Bring the bankers into it, and that way you don't even have to mess with court, whereas with the liens, you may end up having to go to court to because they're going to want to get the liens released. So, I don't know, I'm just really fond of Hartford's process of these criminal complaints, and you can get that. Go to civilrightsfreedom.com. And I downloaded all of his stuff, printed it, and made my own manuals from all the stuff. Whenever I get anything like this, I print it off and make my own manuals on it. So I'm not held hostage to the internet staying up and going. But that would be what I would do. I'd get Hartford's process going of the criminal complaints, and then jump into Steve's process using the BOEs.
Here's another question I have.
You want to hear that? Somebody's got background noise. Please mute your line. Go ahead, Dave.
I've got to go to this motion hearing on the 6th. And it was in the back of my mind that I hereby choose to change venue, and I want this transferred to federal court.
I would preface
again.
I might preface that with an additional motion while you're there to void or to vacate, set aside a void judgment or a malicious prosecution with no witness, nothing but hearsay evidence, no first-party competent witness whatsoever, nothing but the theories of the law enforcement officer as to what happened, who wasn't even there, so he couldn't make an intelligent decision or conclusory theory about anything.
That's correct.
So I'd move for dismissal with extreme prejudice because they have harangued you and harassed you, a malicious false prosecution, and then that sets you for your civil rights violation.
Okay. All right. I appreciate the feedback and I'm going to look forward to listening to Mr. Curry again, as he's a well-spoken and knowledgeable on what he's dealing with. And what I'm looking for with the BOEs, it seems to be taking traction, but I have not in our group or any group that I'm aware of seen any financial remedy for for the injured party. In this case, myself, again, with the corruption in this judicial system that we live under.
Okay, here's something else that I probably should have said and didn't. And I learned this from Hartford again, and that is when you get all done with your case, before you well, you go serve your papers and whatnot. Then take copies of everything and turn it into at least 5 major bonding companies, like Hartford or Aetna, Travelers. Turn the information into at least 5 of them, and then instruct them to get it on their APB, notifying all bonding companies throughout the nation, so they can't just go rebond, and that way they're screwed.
That's a good idea. That's
ditto.
That's an excellent. And who's had to mention that?
I got that information from Hartford Van Dyke.
Who's speaking as I'm asking?
Who's got
the noise?
Yeah, who's got the feedback? Somebody.
Okay, I think it's your line, Dave.
Okay.
Sort of seems like we need to get Steve and maybe some others on this call and Hartford Van Dyke together and have a brainstorming session.
We can definitely set it up. So, all right. Does anybody else have anything for Dave? Okay, Dave, it sounds like you got some things and you got some houses to visit. Thank you, Bill. All right, we're going to move on to Steve Curry. Are you with us?
I am.
Outstanding, and we're pretty close to being on time here. So, back by popular demand, we've got you, Steve, and I know there was some things that we were going to talk about specifically where
Jerry
we
Darby
ended last week. Welcome to the call, Jerry. So if you want to go ahead and take over, Steve, you've got the floor, sir.
My pleasure and my honor, young lady.
Ours as well.
It is incredible to be on Randy's talk show. She's got one tremendous audience and very, very intelligent people out there. And I just have a couple of remarks about Dr. Livingston. Actually, one. I'm going to leave it at one, and I'm going to say, wow, that man has really done his homework. He is skilled. He comes to it with intensity and passion, with intellect, with desire, with the back to desire. He wants to share his knowledge, and this is where it's at. It really is. That's where I'm at. That's where Dave Kofelt is now at. Not that he hasn't been there, but he is there now. That's where my very good friend Chris is at. And it's all for no remediation, no compensation. See, we have this distorted image these days, having been corrupted for decades, thinking that resolve, thinking that our hard work should be paid in cash, should be paid in what? We have a barter system going here. And what we are doing is it's really a pay-it-forward system. In other words, what I learn, my knowledge, what Chris learns, what Dr. Livingston learns, we're paying it forward. And I know that to some that means that is kind of an obscure, abstract, ethereal kind of thing. But no, it's real. And that's what we bring to the table. We're bringing our knowledge and we're dispensing it for what? So it can be perfected. Dr. Livingston's work is phenomenal. And if there's anyone that I would recommend to come back on your show, Randy, it would be Dr. Livingston. He has. I missed the first 15, 20 minutes of it, but it didn't take me long.
No, he's incredible, and we will have him back. We only had him for a short window tonight, unfortunately, so he kind of darted around. But I will say he had my ear for about 2 to 2.5 hours earlier this week, and during that time, by the way, Roger, you beeped in, Gloria, you beeped in. There's a reason why sometimes I don't always answer. Someone's got my ear. And, boy, he walked me through a lot. And I tried to pull some of those bullets from him tonight, but I will get him to teach us on the whole thing, hopefully in one of the next few weeks.
Yeah, excellent, excellent. I could listen to him for several hours.
Mm-hmm.
The man is very gifted. He's very learned. He's very sincere. He doesn't throw any punches that he's not willing to back up with a little force. So you've got the good guy there. He's a remarkable fellow. So my kudos to Dr. Livingston. And I want to extend a special greeting to Dave Kofelt. He's now gone through the fire. And maybe not the fire that tempers folks like Chris and all of that, but Dave's getting there. Dave's a very talented fellow, and what he works with is passion. What he works with is intensity. What I admire about David is he just stood up, raised his hand, and said, "No more. I will not take this crap anymore." And so he did. He did exactly what everybody needs to do, is reach out to those that, either they've been there before or they have knowledge to share. And he did that. And he didn't take everything that I was giving him for granted. He went back in and researched and said, "By golly, that sticks." And he did this very same thing with many other people. So, David, welcome to the club, buddy.
Sure appreciate it, Steve. I appreciate those comments. And I just sent you Dr. Livingston ducks.
Oh, thank you very, very much. I'll look forward to that. If I may, I had a few things that are of importance with the BOEs and relating back to Dr. Livingston, if I could.
And for those that are new, BOE is Bill of Exchange.
Mm-hmm. Thank you, Randy.
You're welcome.
BOEs have been around a long time. There are actually laws all around the world related to bills of exchange and what they are and what their purpose is and what their intents are. And we have all the language. And let me put a plug in here for our new website. It is Four Corner Doctrine at WordPress.com, and it's being assembled and managed by a very good friend of mine, Mr. Rice. On this site, you will find all of the ingredients that you need to put together your own BOE. Now, we show templates and affidavits and all of that, but everyone has their own free will, and they have their own free will of choice. And so they can take our work and replicate them, fill the blanks in, and file these documents. But I would like to see, more than that, people taking up different forms of the bills of exchange, because there are only 10 requirements to the bills of exchange, and I'm not going to go into all 10 of them, but you can see those on our site. I will preface the fact that there are certain things that must be in there. There must be your name as a drawer. There must be the person that you are charging against, that is the drawee. There must be a date. There must be an address. There must be a way to contact both of you, the drawer and drawee. There must be...
Speak up.
Oh, sorry. there must be conditions and terms built within the BOE, meaning we, as injured parties to your malfeasance, misconduct, whatever, there must be a time limit, and we must make known what we are demanding. And those demands have already been done for us. The terms and conditions of the BOE have already been addressed in what we have attached to the back, which is the oath of office. I can't stress enough how important the oath of office is, because it is that point where a man or woman crosses the line from private to corporate, private to collective, private to public, and it is at that point in time that you catch those perpetrators of crime. What they do with their oath of office is they sign their blood signature on that oath of office, and they are ascribing, they are agreeing, they are accepting the terms and conditions of that oath of office. And should they fall short, should they defile or default upon the oath of office, they accept the terms, which include their punishments and penalties. This is something I didn't cover last time, but this is an important...
Steve?
Sir?
Question. I certainly support and enforce the thought of attaching the oath, but would it not be extra frosting on the cake, as it were, to attach their bonds?
Good question. And here is why we do not attach their bonds, because what we are after is a single instrument in commerce, no different than a dollar bill. By law and by all understandings and by all acceptances throughout the international commercial community, we accept legal notes of tender. And in your wallet, you have a dollar bill. It is a single instrument. On the front side, we have the acknowledgments and whatnot and so on, and we have an order to pay. Well, we flip it over, and we have all the information on who is the liable party. A bill of exchange meets all the legal requirements to be tender for the United States government, for all societies, for all cultures, for everything. So what we are doing is having these bills of exchange endorsed by the original signatures, which are the oath takers and oath givers and registrars, witnesses to this event. If you take a dollar bill, flip it over, you'll see signatures on both sides, or on the back side, really, is where the signatures are, of the U.S. Treasurer, the U.S. Secretary of Treasury. That's his acknowledgement, his endorsement of that instrument. We're doing nothing, absolutely nothing different with our bills of exchange. The people that signed their oaths of office have attested to, affirmed to, consented to, acknowledged their permission, their promise to perform their duties. No different than the Secretary of the Treasury is on the back of a $5 bill. What we are doing is taking the oaths of office and we're removing them from commerce only so long as to attach indictments. And our presentments and our claims of remedy against them for the injuries that they have caused because they have criminally impersonated, trespassed and misrepresented themselves. These are all very key elements. And there is not one international agency, government, or system or corporation that could argue that an oath of office, as it sits, is not a commercial negotiable instrument. Our bills of exchange are only announcements, presentments, and indictments of those who have defaulted upon their oaths. And what we are doing is returning, we are escarping, you might say, we are unmasking the corporate persona of the people that signed those oaths of office, and we're returning them to not men and women, but persons who are responsible for having violated their own laws. And this is a subject I kind of wanted to get into tonight, and I hope you understand it. And I need to credit this to a number of individuals. I'll just throw out one name, Mr. Rod Class, who most recently received a letter in the mail to him from the U.S. Attorney General's office, who had prosecuted him in the District of Washington, D.C. And that one question to Mr. Class was, are you representing the defendant? And for Rod Class, me, Chris, and everyone else that's been involved in this work, we're going, there it is. Mr. Rod Class, are you representing the defendant? Mr. Rod Class had been presumably under his full uppercase name been charged with a crime of carrying a handgun in Washington, D.C. against the statutes. Okay. Yet Mr. Class, as an authorized agent of that uppercase corporate name and as a rightful individual man, contested. He said, I am not that man. Yet I am the authorized agent for who you claim had caused a crime. What Rod Class had been waiting for, and Rod Class, the grass doesn't grow underneath him at all. What we were all waiting for was their admission that they are all dealing from a corporate level. Not only that, they are private foreign corporate raiders, pirates, engineers of an insurrection against the people of the United States.
Privateers.
Yes, sir. You bet. Go ahead, Chris. Is that you I hear?
It is, and you're right on point with this, of course. Most people don't cognize that the District of Criminals does not lie within, quote, U.S., but specifically lies without. It's not a part of this country. It is a private, foreign-owned, foreign corporate headquarters for the Club of Rome and the Zionist influences that rule the world's banks.
Mm-hmm.
And, of course, whenever our representatives go to the District of Criminals, they might represent us one day when they swear in, but then they're bought out and paid for, and they represent other interests foreign to U.S. and to America and sell us down the river.
And that they do every single day. And they do it with knowledge, and they do it with intent, and this is what Rod Class and so many others have been able to ascertain and confirm and put on the record. Just to let you know. Oh, go ahead.
I do find it absolutely absurd and insane that they keep trying to poke down these neocon Zionist left-wing liberals as masked as conservatives, like Ted Cruz, Marco Rubio, and Chris Christie, and you can go on and on, almost the full palette of potential candidates that lie within the alleged Republican Party, lie being the operative word, are really a bunch of posers acting like they're conservatives. Cruz, in fact, his wife, I think, is a former executive vice president or president of Goldman Sachs, a big bank company, and CFR, Council on Foreign Relations. You know, that's New World Order as you get. You can't get any deeper than that. So, you know, if people don't wake up, I think we're in deep, deep doo-doo. Thanks.
All right, I have a question. You brought up neocon. I hear that term all kinds of times. I mean, just everybody and their dog talks neocon. To me, it's some foreign hippie name. What is a neocon?
A new form of conservative, which is not a conservative at all, but an imposter, in my esteemed interpretation. What do you think, Steve?
Rhino.
Absolutely agree.
So it's a phony conservative is what you're saying.
Neo means new. Con means trick, artifice, a form of deception. It's a trick.
Okay. All right.
And we can get into that a little bit about BOEs and how we've formulated them as contracts. And if you break the word contract, you have con, which is a form of deception. It's magical trickery. And tract is nothing more than a treaties between parties. So,
or a trick.
Exactly. Thank you. And so you're being conned into a treaty or agreement with someone who, it doesn't have your best interest at heart.
Okay. Then, and that all makes sense. So what do you call a legitimate agreement? Is that what it would be, just an agreement?
A legitimate?
Yeah, one that's not a contract.
You bet.
Well, so if you have a contract that I've always thought was a legal, lawful, binding process, so if a contract is a trickery tract, what do you call a legitimate one, where there is integrity?
One with full knowledge and integrity, one with honor, one with put forth without the intent to evade or avoid or to deceive. Chris, you might have an additive to that. Go ahead.
Well, the original contemplation of contract was it was supposed to be two people coming together with an offer and acceptance to reach a meeting of the minds.
Correct.
Full openness and transparency. So they weren't trying to get the one up on the other or take advantage of one another. They were really trying to reach an agreement whereby both would be better off for the association of the contract and both would get something substantial, whether it was consideration or performance of task or supplication of products.
Okay, and that's what I'm getting at is if, my impression of what a contract was is exactly what you're saying, legal, lawful, meeting of the minds. So if a contract is an item of trickery, what do you call the one with integrity?
Well,
we would call that a treatise.
Oh, a treatise? Treatise?
A treatise without the
even
word
a contract, some would observe, can be carried out in honor and with full agreement and with both parties performing what they agree to in good faith, with clean hands and no ill intentions. But so many pervert the concept of contract to a contrict to seize advantage over people they're sitting down with and acting like they're representing. In fact, most of the time when you go to the bank, you've got a sales agent that's getting paid for selling you up to what they want to sell you to, as opposed to lending you what you want. In fact, they frequently try to add more on to it, and thereby being deceptive because they give you the illusion they represent the bank when they're actually proprietorily interested in their own fiduciary interests, not your benefits.
Okay.
Can I say something?
Yeah. Let me throw this one word in here. It's called gratuitous bailment. Gratuitous treaty, gratuitous contract, meaning it's one side, meaning that the contract is only meant for the benefit and profit and so on of one party.
Unconscionable.
Unconscionable. Thank you. So.
Okay, and somebody else wanted to throw in a comment on that real quick.
Yeah, Randy, it's Brad, and at the risk of seeming rude or chastising, we kind of got down this rabbit trail because the question was posed, what is a neocon? And somebody took the word con and made it all into something deceptive, which standalone is fine, but that was not the correct definition of neocon. A neocon is just that new conservative. It's short for the sort of the political orientation of he's a conservative versus he's a liberal. A neocon is somebody who's a Johnny-come-lately conservative, and they're using the conservative standpoint as kind of a political launching pad. That's the correct definition of a neocon. Con in that context is short for conservative, a new conservative, and we kind of got derailed onto a rabbit trail of being con and deceptive and all that, which is fine. There's nothing wrong with that. But that wasn't the correct answer to the question. It's neocon, somebody who's new or a Johnny-come-lately, sort of in a derisive sense of being a conservative, sort of what we all might think, you know, more aligned with supposed traditional values being conservative values. So that's what I wanted to throw in. Thank you.
Okay, thank you so much. I appreciate that. I looked that up the other day, and I do vaguely remember reading what you said, but I guess lots of people, you know, and I've noticed this ever since I was in high school when the hippie thing started out, that they come up with all these new words, and it's kind of like a fad. Nobody knows what it means except those who are using it. And I feel like I've just kind of been left out in the dark someplace, you know, with some of these terms. So I appreciate you guys, all of you, explaining some of this to help me understand what's going on in society.
Yeah, it's kind of like Al-Qaeda, then ISIS, and ISIL.
Exactly.
Exactly. And then I never heard the word caliphate, and all of a sudden that was all over. So I shut it all back off again. All right, Steve, back to you.
Well, thank you. Just to comment on neocons. Neocons do relate to conservatives, but as Chris will hopefully agree here, you break the terms down, you still have the three-letter designation for con. Serve, itives, serve, who are you serving? Serve, as in the present de facto, serve, as in slave. Who are you trying to con as being a conservative? There's much more to that, and I don't disagree with your diagnosis. I don't. But breaking down the words,
you have to look at it who it was.
Yeah.
I mean, just Bush or Grove, or I mean, any one of them that are not your paleo-conservatives.
What are they trying to conserve? They're trying to con you into thinking that they're serving one thing, but they're serving another.
I agree with that.
All right. And we know all about Bush, and we know all about Cheney, and we know all about 9/11 now, which is really, really important that we all understand that it was an Israeli plot merged in with our own government.
Wait. It is so deeper than Israel. This is outright Vatican Satanism at its highest. This is echelons above Israel. Israel is nothing more than a corporation, the same as the United States is a corporation. Until you start breaking down and seeing how the Vatican is running things through their bankers, and the Rothschild is only one of their bankers. There are a whole slew of them. But
thank you.
It's not a corporate state. I'm sorry.
Go ahead, Steve.
Can we get back to BOEs? I mean, Israel and all that's not going to help me.
Yeah, we can, and I will be most willing to comply here. Bills of exchange, once again, we are looking at promissory notes. Those are the oaths of office. And these are so key to everyone's understanding. Promissory notes are no different, again, than the promissory notes that you would apply to your real estate mortgage. And if you promise to make payment to another person, monthly payments, and 3 months goes by and that person hasn't received your payment of goods rendered, then that person has an opportunity to come in and ask who? Not a court. The first person they go to is the very first person they go to, believe it or not, is not a court of law. Number one, they go to you and they ask you, well, and this is the right of commerce. The lender who lent you the property, either through title or deed of trust or something, he has the obligation to come to you and ask you, is there a problem? Is there something that I should look to remedying? What we've gotten away from is people taking the role of a responsible commercial merchant, and they've assigned it to a league of attorneys and bankers and whatnot, who will immediately attack you because there's money to be made in that. Lenders have gotten conditioned to, well, if somebody doesn't pay a note, we got to take it to a collections agency. The collections agencies are all full. Believe me, they're all full of bar members and attorneys who are sitting there waiting for such a call, because they're going to make what? A commission on what they bring back to the lendor. And some folks are a little reticent about paying a bill that they think is unfair, and they have a right to think that their mortgages are too high because of the usurious interest rates, and they are right on. So they're challenged then by a league of bar members and attorneys and corporate people to attack them on statutory grounds. Well, the law reads that you shall pay because you promised, and you gave what? Your written blood signature on this promissory note. What a lot of folks aren't understanding these days in real estate, and I'll go back to BOEs in just a second. What a lot of people don't understand about their real estate mortgages is that there was and is in all records promissory notes that are less than 25% of their mortgage values. Those promissory notes have already been paid, and here we have these leagues of attorneys and corporations recirculating this original promissory note, charging interest, compiling, accruing 30 years worth of interest, and making a new mortgage out of it. This is a crime. Usury in itself is a crime. But to put, let's say the value of the property was $50,000, to put $200,000 plus in interest and fees onto that principal and make it a new mortgage. What is this? This is inflation. It's extraordinary inflation. And the homeowner, he's going, well, how do I pay that? Because I'm not the printing press. The printing press is on the other side, and it's within the corporation that's charging them this exorbitant amount of interest. They're just printing paper. They can print all the paper they can and all the paper they will on that side, but we don't have that luxury, do we? We're asked to make our payments to a loan mortgage company who has it's a very tiered system of collectors and servicing companies and all of that. And this is where MERS has gotten in a lot of financial trouble, a lot of lawful legal trouble. They've worked their way in to say, hey, wait a minute, yeah, we know we have a lender up here, but we, being the servicers of the mortgage, we're entitled to be the beneficiaries. I don't know how many court cases have gone on within the last few years to take MERS out of the game. They need to be out of the game because these are just scalpers. You got a ticket to a game, and it's $25. Scalpers outside see the demand rise, and they're selling their $25 tickets for $250.
If I might add something to that, Steve.
Please do.
MERS is really what you would call a shell or shill corporation, a phantom corporation, and it's composed of a bunch of bankers who set up this pseudo corporation so they could exchange these notes and deeds of trust and investment vehicles between themselves without having to incorporate fees of making the transitions every time they sold or traded their investments. And so what they do is they appoint their special vice presidents or whatever title they want to give them from their own banks, and they self-police, and they give themselves the authority to make their own assignments and their own conveyances under the guise of being a trust, when in fact there really isn't a trust other than the members of the bank. They made it for their own benefit. And so it's really a sham shell corporation trust used for stealing houses and homes under fraudulent foreclosures.
You got it. You got it. And back to the term gratuitous bailers. Gratuitous bailment. This is where a contract is only one-sided. And they do it to impoverish you, but to improve their livelihoods. So they benefit from your defaults, from your encumbrances.
Your lack of sophistication and your lack of knowledge of how the banking system actually operates.
Exactly. How different is that from our bar members and our judiciary?
You know, Steve, I have thought the bar and the bank and the bar are one and the same, effectually.
They are?
Actually, they aren't just sort of the same. They're not even just allegorically the same. The banker literally is the judge. The judge literally is a banker. They are one and the same role. They're also a postmaster, but that's a whole other dialogue.
Hear, hear.
Well, I'd like to hear more about that, being the postmaster, because we have a disconnect between agencies of our government, where the government has assigned certain tasks and functions to the postmaster. They've assigned certain tasks to the IRS, to all these corporate subsidiaries, and how they all function together is just, it is phenomenal.
It really ties into the office of the postmaster controlling all of it. Believe it or not, the banker is only a banker because he is a postmaster, and same with the judge. And it is by virtue of that position, even if it's a temporary position granted for only a certain time frame, they only have that power because of that position. If you look in the entirety of all of government at any federal or state level, the only individuals in the whole of what we call a country, the whole of it, there are only 2 individuals who earn $400,000 a year. One of them is the President of the United States of America. The other is the Postmaster for the United States Post Office. That man,
the Postmaster General, thereby a military commission?
That's correct.
That is pretty incredible.
Yeah. And you can look it up. The Office of Bureau of LBM will vouch for that. I mean, this is a verifiable fact that the Government Accounting Office can verify. It's so in public record that those are the only 2 souls that get that much money a year that it's indisputable fact.
Well, I have a question for you then. Why would these 2 individuals be given such right, such power, such leverage, such position? Would you have an answer to that?
Well, I can tell you this much. As far as power or leverage, the reason people get what their wage or whatever you want to call labor or even income, it's commensurate to what they're doing. And it is, I believe, fairly arguable that even, I won't say indisputable because I'm sure someone will dispute it, but I would say it's for anybody who can read between the lines, I would say it's an indisputable fact that the office of the Postmaster General is the office, I wouldn't even say below, I would say equal to the President, because the Postmaster General decides all of the other roles, and in the absence of the President, yeah, I get that the Vice President takes his position and everything, but if you look at what gets into the appointed positions, that is the dictate of the USPO. If you remember, Lincoln himself was a postmaster. You will go back and you'll see Franklin. Exactly. Ben Franklin, and everybody who studies history can tell you exactly how instrumental Ben Franklin was at not just the signing of the Declaration or the Constitution, but the Articles of Confederation. Franklin had his hands in everything. He was an ambassador. That man was behind every scene. So you see the people who are most famous in history having a role to play in the post office.
May I offer a more conspiratorial view of the postmaster for those who have an interest in things?
I'm interested in any information.
It seems to me that much like the patent office, the postmaster is an advanced intelligence operation to be able to assess what's going through, monitor communications and mail, and to be able to get foreknowledge about what the movements of people in and out of the U.S. might be that could be capitalized on and converted to an advantage to get leverage to make more money for whomever, or to get a legal or perhaps a tactical advantage against those who revolt against America or try to create a revolution against the illegal government within.
Sounds like a good thing to me. I mean, not good as far as, I get what you're saying. I'm just trying to say that it sounds like that's feasible to me.
Oh, absolutely. If anyone were to devise a conspiracy, that would be, if you wanted to make the real money and have a real power, it would be in the postmaster. And the reason I asked that question, you can convene your own
court at any level.
Yeah. You have hands on all the evidence, don't you?
If anyone wants to tolerate the bloviating from David Wynn Miller, eventually he'll get to a point where he shows the connections behind the office or the level of the postmaster having to do with pretty much every war. Myself, I can only stomach so much Wynn Miller, but it's an interesting listen, I'll say that.
Wow, yeah. Well, you bring some very profound issues to the table, and I really appreciate that. You know, I had made this one observation, maybe 2 weeks ago. My wife and I were conversing, and I had made mention to the fact of how the courts operate when they send out their writs and their summonses and their notices and all that. They don't have to do certified mail. Yet, for us, we need the evidence. If we're going to make a paper trail, we need the evidence that we actually sent out to and that they received on the other end our replies, our responses, our communication.
Well, if you send me your email, I will send you some information that kind of distills what Wynn Miller says about exactly that on function as the judge.
Okay.
Chris would be interested too.
Sure.
Yeah, Joseph, if you would send me your email, I'll put you in touch with these guys.
Is yours Shannon or Randy or who?
Yeah, this is Randy Shannon. You can do support at 42action.org or just Randy Shannon at Gmail.
All righty, we'll do.
Another comment I have on the postmaster and the postal service, and all of this, of course, was constructed within our Constitution by earlier founders, Ben Franklin and others. If you were to go into the airport, that's a point of commerce, right? It's a commerce of people and men and women and all of that. And we have to show our IDs, and we have to be screened to show that we're not carrying any weapons or, we're not going to hurt anybody. And part of that is good. And there's all the security that's built up around all of these other agencies. But the post office remains that one portal that private individuals, private people like myself, can walk into and deposit our communications without any security. We don't have to go through a scanner to walk into a post office.
It's probably worth noting, Steve, that the post office, of course, was quit-claimed, along with the other assets of Corp US, Inc., to our private foreign banksters of the Rothschild cults back in the 1933 Emergency Banking Act.
Mm-hmm.
It is a for-private profits corporation now.
It is. We know that they are a private corporation, no different than Federal Express or United Parcel Service or...
Well, also break that down a step further, though, and recognize the distinction between the General Post Office and the United States Post Office.
Okay.
Yeah, it's almost exclusively the same guy. It's the same individual who plays both hats, but they're two different. It's like saying that the judge who sits at the District Court of the United States is the same guy. It's the same man underneath the robe as the United States District Court. The difference is a matter of jurisdiction.
Mm-hmm. Mm-hmm. This goes back to what Dr. Livingston was talking about earlier when he was talking about a court of law with just a jury. What we all need to understand is that a judge is not the court. And under our Constitution, we established courts, but we had no regulation over the judge. And we know from very detailed declarations made by our founding fathers, Jefferson included, that one of the British constraints to establishing a federal enclave of colonies, British colonies, was that there were a couple of things that were not to be disturbed. One is their commerce, and the other was the enforcement of that commerce, the judiciary. And there was not one signer to the Constitution. There were signers to the Declaration, who objected to that. I said, well, if we're going to leave Britain behind, we need to leave them behind all the way. Yet there was toying with that instrument and the Constitution, which left the judiciary and forms of commerce intact. And the British wouldn't have it any other way. They would not give the colonies any rights unless the colonies agreed to have a continuance of their commerce and their judiciary.
This will really throw you for a loop. And I'm just going to interject the two distinctions, the definitions, and then I'll stop again. Just study the difference, or look up the difference behind dominion or dominium versus rights. And that will beg the question of, if the people are sovereign, why is it that the people don't have dominion instead of simply rights?
Mm-hmm. Mm-hmm. This is probably the best segue I could have asked for. And Randy, pardon me, we're going to leave BOEs behind for just a minute more.
Okay.
The discoveries, the works of Rod Class against the federal governments, he had 4 federal district court judges admit to him on the record that they are a private foreign corporation.
And that he was right.
Pardon me?
And they further confessed that what Rod was saying was right.
Yes, they did.
That's massive, because the only way they can say, you're right, but we're still going to penalize you, is because Rod did not change his status. He was still a public U.S. citizen.
Correct. Thank you for that. A citizen, as defined under their law, comes under their jurisdiction. Yet Rod is very active in pursuing the idea that he's not just a citizen, as they call him. He is an American national, a sovereign, and more importantly, he is a man on the land and not of the sea.
Well, that's all well fine and good to say if you're going to correct your status. But if you're not going to correct your status, they're operating under the presumption that you're still a public U.S. citizen.
Correct, sir. Correct. I think Rod's in that particular area right now where he can revoke, and he just did, in some papers that he just produced, he is actively pursuing the disenfranchisement, the depatriotization that they have cataloged him as a citizen. He's now merging no less than a cocoon into a butterfly. He's emerging now as the rightful heir of his birthright, which he's challenging, and others have. A birthright before contract gives man and woman the opportunity to identify themselves as natural, free men and women on the land and not of the sea. This is so important, and it's really important in processing our BOEs. We're not really out for their money. We are not. And let me make that very, very clear. We're not out to make money on our BOEs. We're after those people becoming responsible and accountable for their own laws, which their own laws indicate if you harm somebody, you will be fined that amount of money, $100 million. A lien may be placed upon your assets.
Hey, Steve?
Yes, let me conclude with that one statement. Those that make the laws must be obligated to them. If we as men and women are not a part of making the laws, we are not obligated to their laws. So I'll yield there. Go ahead.
Okay, this is Wayne. I am, I guess, kind of torn on that. I am a patriot in the sense that I very willingly share my information for free and everything with everybody, online and whatnot when I'm doing my thing. But I also feel that when they wrong us, they owe us. Therefore, it is not free. At least that is my attitude. I have not collected anything yet because I have not finished the case to be able to turn it in. But like I said, I have no problems sharing my time and energies with other fellow patriots. But I have a major problem with them screwing me and me not getting anything for it.
Can I ask, were you using pure perfect equity, or were you using a statutory remedy? Like
I stay away from statutory. I am using Hartford's process and Steve's process, getting ready to, now that I've been introduced to Steve's process, I'm merging the two.
Oh, I'd love to see that. I've never seen anybody use both Hartford's and Steve's work together.
Well, Hartford has the criminal complaints, and okay, and he also has the lien process. And like I mentioned at the beginning of the program, I like the lien process, but I don't like having to go to court. The bankers are really... If you're going to ask me a question, let me finish the statement, okay? I don't like being interrupted either. I'm kind of a fanatic about that.
Everyone be civil, please, on the
yes,
call.
I know, but it's very distractive, and with me having Morgellons disease, I can't. It's hard for me to maintain train of thought. And I've lost it. I have no clue. It's gone.
Well, let me help you. You're just discussing the merger of Hartford's work and the BOE's.
Okay. Right. Okay. Thank you, Steve. The process of using Hartford's criminal complaint to me is very logical, plain, and simple, except that it's best if you handwrite them, and I don't like doing that. But anyway, and then get the bill of exchange process done, which I'm just now learning, so I can't really speak on any kind of experience on that. And then once I'm all done and ready to serve, then and make up the list that Hartford talks about where you serve papers, and then you document exactly when you serve each individual, and document it right down not only to the date but to the minute, because that's very critical with bonding companies, and it costs them a lot of money, or could potentially cost them a lot of money. You want to document it specifically to the minute when you serve papers, and then you give that list of papers or the list of serving times to the bonding companies so they know exactly when you serve papers on those individuals, so the bonding companies know exactly when to start the 30-day calendar, so that if those, I'm going to call them criminals, just to be blunt, when the criminals don't report back to the bonding companies within 30 days exactly to the minute, their bonding has stopped. They jerk the bonds. Okay? And so I like Hartford's process of doing that. I'm just now learning Steve's process of the bills of exchange, which to me brings the bankers in, who are basically they're right in there with it. And as Steve said, the bankers should be wanting to work with us, because if they don't, it exposes their fraud. And by sharing the monetary end of it with the bankers, that gives them extra incentive to want to work with us, and therefore we should be able to collect our money from having been wronged, injured. That's kind of how I see it as working, but I'm a beginner. I have not finished Hartford's process yet. I'm mostly done. I'm all done filing up my charges, but I'm now at the point where I need to learn Steve's process, doing the bills of exchange, and then once I get all that done and serve the papers to everybody, then go deliver these papers to the bonding companies also, with a notice for them to post it on their APB. And then you got them nailed. from what Hartford says, they'll almost always basically thumb their nose at you and fail to report to the bonding companies, and then the bonding companies automatically jerk their bonds and they're done. And since they've posted it on their APB, they can't just go get another bond from some other company. They're done.
Absolutely correct. And if I may, that was a very good explanation of Hartford's process. Let me explain, and we'll get back to BOEs right now. The advantages or the attributes of a BOE is that it does expose the bankers immediately. It does expose those people who have defiled their oaths of office. It does put those people who have defiled their oaths of office in an indictable situation. When we talk about indictments, we're talking about presentments. The last thing a public official or a judge wants to see is his name up in lights. He doesn't want to see his name in the legal files in his local newspaper. But that's what he gets with a BOE. One, he's already consented. He's already accepted the punishment. This is what oaths of office are. They're promissory oaths, and if you trail back to the very beginnings of the oaths of office, they are all promissory oaths, and people that take these sorts of oaths accept the punishments and penalties should they default. This is not something that they really want to do. They don't want to stand up and admit to their malfeasance, to their treason, to their sedition, and et cetera, et cetera. That's the last thing they want.
Okay, Steve's got a question on that at that point.
Yes, please.
If the bonding companies are not responsible to bond criminal conduct, what is the possibility of these guys even having a fraction of what they have promised to be liable for should they screw somebody?
Oh, you asked the perfect question. Are you familiar with a little article? It's called 15 USC-1.
15 USC-1? No, I'm not, but I will be.
I'll tell you what. Let me read it to you. I have to bring it up here real quick so I can get it verbatim here. Give me half a second. Trying to think what document I put it in last. Let's see here. Hang on. Basically, 15 USC deals in contracts. Okay? And if you default on your contract, you are liable for suit. You're liable for prosecution under United States laws.
I have it here, Curry.
Oh, thank you. Go ahead, David.
U.S. Code 15, U.S. Code 1, trust, etc., and the restraint of trade illegal penalty. Every contract, combination in the form of trust or otherwise, or conspiracy in restraint of trade or commerce among the several states or with foreign nations is declared to be illegal. Every person who shall make any contract or engage in any combination of conspiracy hereby declared to be illegal shall be deemed guilty of a felony and on conviction thereof shall be punished by fine not exceeding $100 million if a corporation or if any person $1 million or imprisonment not exceeding 10 years or by both said punishments in discretion of the court, and this is one of the docs I filed into my paperwork.
Well, that's fantastic. But what do you do if they don't have it? And I can't feature really too many people having that kind of money laying around.
CAFRA funds.
You tap the CAFR funds, you tap their QSIP numbers. Every person with a birth certificate has been assigned a QSIP number.
Right.
Judges and lawyers are not exempted, even though when they signed up for the bar, they became a non-citizen, and that's what protects them, by the way. As a non-citizen, they use powers of usufruct, as in military law, to protect themselves. Lieber Code and all that garbage goes out the window when you decloak them. What we're doing with the BOE process is taking their immunities, as in their corporate immunities, and shoving it up their butt. Pardon me, Randy, for using that. But we disclose them clothes. We disclose, we take their clothes off, and we see the real individual, the man and woman, who, at the point of their oath of office, decided through a free will of choice to accept all of the corporate rhetoric, all of the corporate bantering, all of the corporate incentives, so they could be wealthy. And the corporations, of course, incentivize their deeds by giving them power. And I really want to touch on this point real quickly here, because the bar, as in the federal bar, as in all courts, we know all courts are federal down to the municipal level. The ABA, who devised the Supreme Court, who devised the bar, who devised all of this shit that they're trying to dump on us, they term themselves to be self-regulating, self-appointing, and self-healing. In other words, they're the only people that can oust a judge. How bizarre is that?
It's about as bizarre as being self-policing. How's that working out? It seems like a clear and present danger to the national security to me.
You betcha. And this is why we're challenging them on public hazard bonds. Back to bonds for just a minute. The bonds people, as in the insurance people, the bonds are all underwritten by larger insurance concerns. We've proven this out in Colorado. We caught a franchise called County Technical Services who were purporting bonds onto all county public officials, but without any lawful or proper product or services being rendered for the premiums that they were receiving. They don't supply anything as far as relief or remedy for an injured party. None of it. All they do is embezzle and misappropriate public funds, and it's a one-way street all the way to Shanghai, China, or the Bermudas.
Okay, Hartford has a neat remedy for that, I think, if I understood what you said properly. And that is when you serve papers on the bonding companies, you serve them to at least 5 major bonding companies with the instructions to post it on their APB, and that lets everybody know who is self-bonded. It exposes, he says it, he compares it to like putting an ad in the newspaper. He said it lets all of those self-bonders know that they had better honor it, or they are in deep doo-doo as well.
He is very correct. How the BOEs fast-track that, if I may, is that the BOEs go in as $100 million liens, and we don't use that terminology. We use it as actions at law. Every one of our BOEs are accepted as instruments in commerce, and they can't be diffused. They can't be sidetracked by any legal trickery. every bond that we filed ends up on the board of directors table, whether it be Wells Fargo, Regions Bank, Colorado National Bank, Tennessee National Bank. All of these articles are they become part of the fabric of that corporation, and they are all to be looked upon. And what we've done in the BOEs is to take out any intervening unsecured third parties, as in the courts, as in attorneys, as in legal counsels for the bank. So having done that on the very face of the bill, these are legal tenders, remember, payable by the U.S. Treasury in some areas. They must be reviewed by the board of directors. The board of directors then must, because of their fiduciary duties to their shareholders and investors and clients, they have to record a $100 million liability against an individual, a person, a corporate person, or a man and woman that we've assigned, that we've designated. All of that information goes into their bookwork. Who looks at their bookwork when it comes to loans? But the corporate regulators called Dun & Bradstreet, Moody's, Standard & Poor's, who are all giving ratings to lending rates to certain counties, county corporations, states, and whatnot. If they see that they have a $600 million liability against a single county, the bond rating that they send back to the bank is 0 or less than 0. That county is not going to receive a good rating when they go to apply for credit to run their operations. They're not going to be loaned any money. So the BOEs, again, they're a multi-pronged instrument of exposure. We're exposing the bankers, we're exposing the bonding agents, the insurance agency. Here's something that's very important. We are usurping the courts by saying that there's no third-party intervention allowed, and everything must be done under the supreme laws of the land, which refers everything back to the organic constitution, kind of before bankers, if you would, before all of this crap. And we've outed the bonding and insurance companies. All we're using the insurance and bonding people for, and they've already done their task, they've assigned a value to those oaths using 15 U.S.C. 1. $100 million per event, per person, per offense. $100 million for every single signature on that oath of office. And we've had major success in getting that message across. No, our intent here is not to make ourselves money, but to enforce the Constitution of the United States.
Can I interject?
Yeah, just let me finish here real quick. We use the BOEs no differently than our founding fathers were trying to use the Constitution to prohibit and constrain anyone that would violate an individual's right. So, I'll yield. Go ahead.
Yes, I sort of agree with the gentleman who was talking before you about, we put these BOEs into commerce, and yeah, the judge might get pinged, he might get fined, but it stays in house of the bank. If I don't get a remedy of money for the injury that they've taken from me, it really doesn't do me a whole lot of good. Case in point, foreclosures, throwing me out of my house, putting me on the street. Yeah, the judge, I have to sit and wait for time when the judge or whoever I put this on a public official decides to sell their house, and then they have this big fine in front of them, and they change their mind and say, well, I just won't sell my house.
Why? There's a couple things that most people in foreclosures don't take into account. One, it's required that they show you the loan or the note. They have to have both.
That sounds great outside of California, but in California they could give a hoot.
No, it doesn't matter if it's California, Texas, any other non-judicial state. If you come in with your own claim, a private claim in pure equity, and you say, look, you have not shown a note, you have not shown a loan, and so I don't have any proof that you're any bloke off the street that doesn't want to just screw me because you think that you happen to know that I was in some kind of mortgage agreement with someone and you want to say that you're him. Show me that that's you I owe my money to instead of, John Doe down the road.
Okay, what you're saying then is show me the wet ink signature on the contract.
Right, where I agree that I owe John Doe money, and where
Correct.
John Doe's signature is also agreeing to the same one, the same contract.
And I have used that, and it has worked perfect. Not on real estate, but it works perfect. Show me the blue wet ink signature.
You say not on real estate. What did it work on?
It was just a cell phone. Somebody sent me a bill for a cell phone, and I said, I fired off a letter. And if I remember right, they were threatening. I don't remember what all, but anyway, I fired off a letter right back to him, and said, "You show me the wet ink signature where I have signed a contract with you, and you are treading on thin ice with a lawsuit here." And I got a letter back within like a week or two. I think it was about a week and a half, something like that. Said, "Sorry, this account has been closed."
There again, it seems to work on credit cards, automobile loans and stuff, but the mortgage industry seems to be Teflon Don, just like John Gotti.
Wait.
I'd like to mention about my own experience. This is Gary. I went into court. I demanded the wet ink contract, and the judge accepted not only first-hand testimony from the attorney, but also she accepted a copy as good as the original, and I lost my house.
Did you do this as a public U.S. citizen, or did you do this as a private citizen in pure equity? In other words, did your case number have the letters CV like Charlie Victor, or did it not have CV in it?
I believe it had CV.
Yeah, that's public. You were tried, my friend, at a military tribunal. You were not given You were not given peacetime civilian equity.
Well, I was railroaded. There's no question about it.
Well, they'll railroad every public citizen, not just you. Don't feel bad.
When you say
the
CV,
thing is,
what do you have around CV?
CV is what they give to all of their public documentation. Every docket in the whole country has CV in it if it's a military tribunal.
I had a CV. How do you get around it?
You have to first correct your status to be that of a private citizen. You can be a private American national, you can be a private state citizen, you can be a private citizen of the United States of America, but you cannot be a public U.S. citizen.
What about a UCC3 filing?
Even UCC3, I won't go down the rabbit trail, but the point is, even UCC3 does not, I get where you're going with the presentment, I really do, but it does not address your correction of your status, and that's the first thing.
Oh, UCC3 is a status.
Well, it's the status of that, not the status of the man.
Oh, well, that's not what my UCC says.
Well, first off the bat, UCC is a Uniform Commercial Code.
Yeah.
Who has the cipher to that code? Do you have that cipher, sir? No. They didn't give me a cipher for it, and I can look up code and I can look up cipher in a regular old Webster's as well as any kind of Blacks or Bouvier's. And it says that you got to have a key. You got to have something with which to read the code. Right? I've never been given that key. Have you?
Correct. Let's bring Chris
in here. How do you spell cipher?
Sorry?
Chris, if you're still there, Chris has a wonderful line on UCC.
The Universal Canaanite Communist Code.
Amen.
Well, it is the law of the sea, the pirate's law, the law of the privateer.
You're right. You're right. It does go back to canon. It is nation language.
Absolutely. This is where it comes from. Ancient Sumer, Babel, and the Pharisees.
You got it. Absolutely. Absolutely.
Okay.
So what we're faced with here, gentlemen and ladies, is the fact that we must know who we are.
Right.
We are not creatures of the sea, are we? We are men and women on the land, of which there are no statutes, codes, ordinances whatsoever written in any of the court's languages that deal with us. There is not one statute that deals with a man or a woman on the land.
Right.
So this is our point of argument. This is where we must take our stand. And this is what Rod Class has so eloquently put forth, and what he most faithfully challenged the federal courts with, and he got them to understand that they have no jurisdiction over a man or a woman on the land. They have all the rights and rules and all of that for anything at sea, because it is a very fluid element to planet Earth. And this is where they've taken up their hold. So we are not creatures of the sea, even though we may have evolved from there, we are not now.
It's not even just Admiralty, though. That's another layer, I agree. And I get where UCC and Admiralty bring you back to the sea, but it's a deeper deception than even that. If you're on the public, you're going to get that CV on your case. You have to be a special private appointment to the equity court, the pure equity, not statutory equity. They'll try to throw you in chancery. It's less important whether they call it chancery or equity or exchequer, so long as it is pure and perfect and not the term statutory. If they call it, pure chancery, or if they call it perfect exchequer, that's fine. The idea being it just can't be the statutory side.
Where do you suppose would find that sort of court? What would be titled as?
Well, like I was saying earlier with the United States District Court versus the District Court of the United States, it's usually, like I said, from state to state the name will change. Some states might call it, like Delaware, for example, will call it chancery. Now, other states might call it equity. Other states might call it exchequer. It really is irrelevant what it's called, so long as you're not dealing with the statutory side of whatever your state calls it.
I generally agree with what you say clearly, although I think it is specifically important what you call it and how you describe it. And the small d,
I agree with that, but what I'm saying is for your state. The answer will change for your state. So,
but
you have to find out how your state calls that.
Listen to me. When you're going to the small d, small c district courts of the USA, which is in the 1789 Judiciary Act set forth for the American people, it is, in fact, you're right, foreign to the U.S. district courts. And those are foreign jurisdiction law courts. And there are particular word phraseologies and terms one would incorporate into the petitions, pleadings, and motions to identify what jurisdiction and venue you want to move your case properly into. And that is...
I get what you're saying. I really do.
Well, like I said, I was agreeing with you, but I was trying to delineate where you thought it would be, and you confirmed for me that, well, I have observed that that is the only one true court for Americans who enjoy rights which are incorporated some of into the Constitution, but they really come from our Creator by the nature of our creation, by the one Creator of the universe. And so whenever we phrase these things, they must be properly phrased in the explicit words that are set forth in the Constitution, and to the small d, small c district courts, the general courts of justice with lawful justice, not mere magistrates, posing as justices, enjoying life-tenured appointments at the hand and silver POTUS, and compensations not diminished during good behavior. And when we put that language that comes directly from the Constitution and from the Judiciary Act into our petitions and pleadings, it forces them to sit in the proper jurisdiction to hear our cases. I'm not sure you're going to change the CV nature, or if it has a great relation on how they sit when you properly move them with your own verbiage, if you will, or linguistics, and show your knowledge and competence in the law with the expressions that transmit that knowledge clearly to them so they know they're not dealing with an average yo.
Well, you're right that there's a competency test, and you're right that the upper and the lower and all that do matter. If you want to know what I would personally style it as, I would go with the district or the general district court of pure equity. That's all I would say, and all of it would be lowercase. But again, I want to go through the postmaster instead of the particular state because I know that that's the highest one. And now, each state's different. Like I said, Delaware, where I'm from, Delaware will call it the Chancery Court. So you would call it, to get specifically to the pure equity side instead of statutory equity, you would call it the pure Chancery or perfect Chancery. But you would specifically, when you're getting what's called a special appointment from the court clerk, not the clerk of the court, same gal or guy or whatever, in this case it was a gal, same gal, but instead of saying clerk of the court, it's the court clerk. And
but she was the ex officio clerk of the court.
Yes, yes.
Well, if I may, break it down to the very nub of the issue here. All of our courts have been usurped and taken over by a corporation from the very beginning. And so what Chris is saying and what you're saying there, young kind sir, and you're very knowledgeable, by the way, it really has to do with their jurisdiction as a foreign entity on American land. This is the most arguable, most prolific, most profound statement we can make to them is that they have no jurisdiction, that they have designed in their system constraints against themselves, meaning they cannot proceed against us without our free will consent. And they may not presume anything. So, go ahead.
This is Jim from Kingman, Arizona.
Hey, Jim.
How you doing? I need to know a couple of things, so be patient with me.
Go ahead.
I'm looking for your name. What is your name?
My name, sir?
Yes.
Steve Curry, sir. I don't mind telling you.
Okay, I'm looking at the Title 42 email here, and I've been trying to figure out who's hawking when.
We're going to go into Roger here shortly.
Oh, yeah.
Okay, Steve Curry. Okay, do you have a website, Steve, or any contact information?
We do. It's called Four Corner Doctrine with a numeral 4. Four Corner Doctrine .wordpress.com.
Yeah, it's right there on Randy's site and email.
Yeah. And I'm very excited to tell you folks that on this particular website we have all of the BOE information. We have templates and we have just oodles of information, and as quickly as we can get it up, we will. We'd love to connect with any other networking out there. As in Randy, as we're already connected with a very good friend of mine in California who's got 500 odd posts of very relevant information. Veterans Today, whoever would like to get connected with us, we'd like to get connected with them because we are establishing committees of safety here if I may use that term loosely, committees are nothing more than people like you and I connecting with good, solid information that's helpful to everyone. And that's our mission. So, from Arizona, did you have something else, a question?
I didn't even get to my point yet. Everybody got sidetracked here.
I'm sorry.
I have a really important problem. The corporation's trying to put me in jail. Right? Let's start with that. I did almost everything right. I'm sure I made some mistakes. They put me. They did a falsified grand jury indictment against me. They brought me before the court. We know all about the straw man and all that crap. They didn't pay attention to nothing. I did not give them any kind of jurisdiction. I challenged their jurisdiction, and the only thing that kept me from right then and there being under their jurisdiction is some of the things that I have learned from some of these calls, and I just kept telling the judge, I do not give you consent. So he asked the pretender there, the county attorney, and the county attorney said, well, what he should do was just put a motion of not guilty in for me and assign me an attorney. Which he just falsified the records and started practicing law over the bench, and I told him that.
Did you rebut and reject? You did
Hang
not
on just a minute. I want to finish my story, okay?
Hold on.
So with this in mind, I want you to understand what the problem was, so that your bill of lading or bill of exchange, I'm sorry, how can that play into a criminal case or any of these kind of cases where they will not listen to anything? I've quoted I don't know how many Supreme Court rulings, especially on jurisdiction when it's challenged, and the judge said right in the hearing, you don't have a right to stop this hearing. And he's full of crap as a Christmas turkey.
He's right. You have a duty.
There you go. So, you see, they know what they're doing. They're criminals in a criminal enterprise. But how do you stop them?
Bonding.
I sent an impeachment in to my state representatives. I sent a criminal complaint to the DOJ and to the FBI. It's probably going to fall on all deaf ears. Who knows?
But nothing happens there. Nothing.
But did you notify the bonding company that bonds?
Well, I haven't got that far yet.
Okay, that's
the reason I'm in this problem.
Yeah.
I put a notice of an NOD against the judge's bond, and they said I harassed him under Arizona law, and because he's a public official, you can't write a non-consensual lien against a judge. And that's what they brought the charges on.
Okay, let's start with Steve. Steve, go ahead with your response.
All right. Just to consolidate this for you, sir, go to our website, the Four Corners Doctrine .wordpress.com. Mm-hmm. Download some of the material that we've already uploaded there. Study it. From the get-go, from what a bill of exchange is, promissory notes.
I know what a bill of exchange is. I went through Tim Turner's process. I'm a secured party creditor, and they just blew that off, too.
Oh, I understand. Now, this is the difference that you can make in Arizona. We have a lot of people that will help you out with this process, including sheriffs in Arizona. Trust me.
Really?
Yes, sir. We have constitutional sheriffs down there that will intercede into your matter if things get a little hairy. We have sheriffs all around the country that are stepping up and enforcing the law. Believe it or not, I know this is a far stretch for a lot of people, but we can because of, let me put it this way. We have sheriffs in Colorado that will go in defense of you by reaching out to sheriffs in Arizona. We have sheriffs in Nevada that will reach out and help you.
That's wonderful.
That's how
I got
our
spelling
network
here
is
something. I'm trying to get on your website right now. It's Four
When
Corner.
is your next?
Hello?
Hold on, Keith. When is the next court date for you, sir?
April 1st.
So it's around the corner.
Yeah, next week.
We have a document for you, and we've just revised it. I've got to get an upload to my good friend, but you will have a template in your hands by tomorrow morning that you can file with that court that will stop them in their tracks.
Okay, well, I did an interlocutory appeal. They ignored that, too.
I know. They cannot stop this paper.
Okay.
There's no way they can stop
I'm doing something wrong here to get on your website. It's Four Corners or Four Corner?
Four Corners Doctrine.
DOCTRAIN?
No. Four is in the numeral 4. Four Corners Doctrine. Dot.
Okay.
WordPress.com.
It's right down there at the bottom of Randy's email. There's a little red B.O. and Rocco or something or other.
Jim, are you getting my email?
Yes, but I don't see that here at all.
Yeah, look down towards the bottom. Go down. Scroll down.
There's 2 emails here that I got from Randy today, and I don't see anything with that on there.
Huh.
Okay.
Hello?
Here's what you do. Send an email to me if you would like to, or to Randy. She can get it to me. And we'll get the information to you. There is a document called Quorum
Quorum Nobis.
Thank you. Quorum Nobis. And it is one of the most powerful documents you will ever see, and it will mystify the judge so much and scare the prosecuting attorneys to where they will run to California and jump in the ocean.
I like that.
That would be too good to be true right there.
I will guarantee you 98% that that's what they will do.
Where is the link? Which link do we use to get to that, Steve?
The Quorum Novus?
Yeah.
Go to Four Corners Doctrine.
Yeah, I've already got that. Got that. You have pages and you have welcome and whatnot.
Yep. Go on the right-hand side.
Okay.
And down to the bottom. It should be down there on the right-hand side. I believe Mr. Rice posted that today. If not, we'll get it up by morning.
Under welcome?
Well, you have the welcome and then go to the right.
And it has pages.
Yep.
Okay.
I believe Mr. Rice posted that this morning. It's a wonderful document, although it is not transmittable in its present form, but it will be by morning because I've been working on it this afternoon.
Okay, what's showing on mine anyway is 1062, Four Corners Doctrine, bar history, bills of exchange info, related links, related news, videos, welcome, conference calls.
All right. I'm not sure where Mr. Rice put it. So you'll just have to punch those up as you will.
Okay.
My thinking is here he put it in related links or related documents or something.
Okay.
If you don't see it, just respond as in a comment to the site with your email, and we'll get back to you tomorrow.
Can you just reiterate that URL?
Pardon me?
Can you just reiterate your URL? I was having trouble finding Four Corners Doctrine myself.
Oh, excuse me. It's numeral 4.
Right.
Corners.
Right.
CORNERS. Doctrine. DOCTRINE.
WordPress?
WordPress.com.
Okay.
Okay. Related news is where you can go to leave a reply.
Gotcha. I was looking at a word.
Leave a reply. Now, let me tell you that the document I got from Rod Class yesterday, and I've received many emails about this, that it wasn't transmittable or transferable, and people just couldn't work the document. So what I've done this afternoon is revise it, and we're going to repost it as a workable document. You can download it, just write in your name, write in the judge, write in your case number, file it.
Found it.
Okay, Keith, are you commenting on this?
I wanted to ask some questions on the BOE.
All right, well, hold that thought. Let's just get this guy his remedy real quick.
I found the document. It's under related links. This is Ron.
Related links. Thank you very much.
Yeah. It's at the very near the very bottom of related links when he clicks on it.
At the bottom, you said?
Yeah, it says scan Retina files, WordPress, and it has Quorum Novus in it in the reading. And the what do you call it? The verbiage.
Cool.
Scanned Retina.
I got it.
Okay, does anybody have any other comments or help for Jim?
Hello?
Yes, go ahead.
Hello. He is not being recognized in the court as American private citizen, so you have to approach that way.
Well,
otherwise, you be hammered in that Admiralty court.
Okay. Let me explain to you exactly what I did.
You can contact me, and I can give you some instruction.
Okay.
And you may want to have all the remedy you can, and you can use all of it and see which one works.
And, sir, you need to pay close attention to Gloria. She's a very, very intelligent young lady. So go ahead, Gloria.
Okay,
yeah.
Gloria.
So basically, they're not recognized by the court, and because you never submitted any evidence to the court. So you got to prepare some documents, and you got to submit to the court on a private side so that the judge could recognize you.
Yeah, that's where I get confused.
And so you can contact Randy and get my email and let me know, and I'll give you about an hour to give you some free information.
I sure appreciate that. Thank you very much. I did put a flag on it, an American flag on my documents when I challenged their jurisdiction. I put a stamp on it. I signed the stamp.
No, that has nothing to do with it.
Go ahead, Gloria. I'm sorry.
Well, anyway, I'll tell when I contact you. I'll give you all the things I did, and you can tell me where I went wrong then.
Hey, Steve, Curry.
Yeah, none of it that you did is court is recognizing it.
They don't recognize anything anyway if you did it right. But if something works, that'll be wonderful.
They go by their codes. The codes rules basically states that you gotta submit the evidence certain way, otherwise it's a null and void. So you have to follow their instruction. Their instruction will say what documents they will accept. So that's all written in the court rules, federal rules. It's in the codes, but usually don't people read because these laws are just rules and regulations. They're so long. Mm-hmm. People do not like to read, but it's very important. Like a federal rule of evidence. The rule of evidence is very important because they will accept certain kind of evidence into the court. And most of people do not follow these rule evidence. And the rule of evidence talks about how you can authenticate the documents, what kind of documents they will accept. Once you do the right thing, you will be okay.
That's interesting. Rules cannot abridge rights according to their rules. And yet they make rules to abridge rights. That's what confuses everyone.
The thing is, public U.S. citizens only have privileges. They don't have rights.
Absolutely.
Actually, people say codes and rules and regulation does not apply to the people, but there is a certain kind of things that you have to follow. When you do an affidavit and you just sign it and with no witnesses or some authority witnesses and do an administrative straight oath. It's not affidavit.
Or you're getting sketchy.
Oh. Can you hear me?
Good. Yeah, now it's good.
So, like if you are putting an affidavit, if you do not do certain things, then affidavit is not good. They can challenge that affidavit. They break it apart, and so you gotta make it sure that you do a proper affidavit. Do you understand? So when you put evidence into the court, you have to swear everything.
You have to what?
Whatever you put into the court, all that
swear
evidence
or affirm.
a certain way. Otherwise, it doesn't work. Whether it's under common law or admiralty, it doesn't matter. You got to follow certain rules. You got to have somebody administer oath, things like that. You know.
Well, if I may.
And any copies not admissible unless you take an oath for that. That is true, correct copy, and I could testify to the fact that that is the original paper, or you know what I mean? So there are certain things that you have to follow. Because of a human being, you are not a human being, or you are a human being.
It's sketchy again. Gloria's sketchy again.
Yeah, you're underwater.
So,
yeah, if I may, Gloria, again, we can usurp all of these court rules and codes and ordinances if we enter our identities as a natural man or woman. And what you're going to read in Rod Klass's Coram Nobis, which I revised and added to, you're going to see what kind of power you have as a man, not as a person. A person is a slave.
Right.
They are bringing you into their jurisdiction as a person, uppercase. They're bringing you in as a corporate entity. They are assigning you an office within the corporation. What you need to do over and over and over again is to tell them that they do not have your consent to do so.
I told them
and they are under federal law, as in the Federal Code 4J. They cannot operate outside of their corporate boundaries either. So in violation of that, what you do is report that violation to the feds, as in the Supreme Court, or your local district governor, the governor of your state, that this is going on. States' rights overrule federal every time. People's rights overrule states' rights every time. The feds have no actual jurisdiction over anything concerning natural man or woman. Never,
unless you correct your status, Steve.
Pardon me?
Unless the status of the man or woman is corrected.
You must correct it. Yep. You must state your identity.
I did.
You must know who you are.
I did. First thing I said, I am the flesh and blood man on the land, and I am here by restricted appearance, only to challenge jurisdiction, and I'm not here to testify or to plead.
Jerry, did you reclaim the bond?
Go ahead, Charlie. Ask him.
I said, I'm talking to the gentleman in the Arizona. Is it Jerry?
Jim.
Sorry. Okay, yeah, Jim, did you reclaim the bond?
Reclaim the bond?
Yeah.
I don't understand.
Your birth certificate.
You mean orally or with in a brief?
No, did you
okay,
reclaim
he doesn't get it, and that's okay.
Well, I reclaimed the bond when I became a secured party. And they have that 33 pages of information.
Okay, Jim, under UCC, a secured party creditor is supposed to stand. However, when they incorporated, like in Colorado and every state, like it's under, UCC is under Title IV.
Mm-hmm.
It's under statute. That's their get out of being lawful. Okay? So they're operating under statute, even though they don't disclose it. And they do that in every state.
Mm-hmm. Got you there.
And, Chris, I know Chris in Nevada. Chris, if I'm wrong, I think it's when they adopted it under a particular state, under the revised. UCC is not a bad code as codes go.
Mm-hmm.
Okay, because it does separate the debtor from the creditor. But when they put it under statute, I think that's when it really got messy. That's my take on it.
Well, my original question was, how could you just give them a bond? How can you just pay your way out?
Noise. Hold on. Find the noise.
Yeah.
A lot of people told me I could just pay my way out of this with a BOE or any of those kind of things, UCC things, and I've never seen anything work.
All right, so
I haven't either.
Yeah.
All right, let me jump in. Hold up, everyone. We have been holding Roger. We're about half an hour past him of having Roger, and his case was dismissed. He had a case, and it was dismissed. Roger, are you still with us? Might have already lost him. Roger, are you there? Hang on, I might have you muted. Hold on.
While you're trying to get him, somebody mentioned a cipher code. How do you spell that? SIFER?
Charlie, Yankee, Papa, Hotel, Echo, Romeo.
Well, no, that's way too fast for me. Charlie, Yankee, what?
Papa.
Okay.
Hotel.
Okay.
Echo.
Okay.
Romeo.
Okay.
What was your email, sir?
Mine?
Yeah.
1819 March 12 at gmail.com.
All numerals?
Yeah, 1819 is numerals, March all lowercase, 12 numerals.
Awesome. Okay, thank you.
Okay, I want to bring in, and Keith, I know we're going to get back to BOEs, I promise. But I've got Roger on. Are you there, Roger?
Yeah, I'm here.
Okay. If you would tell everybody what you did in your particular case, and we'll bring it all back together so nobody go anywhere, what you did with your case where it got dismissed, and then when you actually had another court case come up, the same judge saw your name and dismissed it before it even got anywhere. What did you do? What happened?
Okay, well, first of all, let me just make this comment. I got married in 2001, and my wife knew this judge from going to church with her, long before we got married. So there was kind of an acquaintance there, but he did not know me. So just keep that in mind when I tell you this.
Okay, go ahead.
It happened on March 2006. We had a contract with DirecTV. I was paying $89 a month for everything but pay-per-view. Always sent the payment in by money order and always in the first of the month. On the 9th of the month, I would go check my online account, make sure that they got it and they cashed it and there was no problems. This particular month, they did not cash it. So I called them up and I said, okay, what happened? They said, we never received the payment. They told me that, I had like 40 days. They were going to cut me off at the end of April. And I said, no, you're not going to do that because I sent a payment and I'm going to have to track this down. So just to keep things on an even keel, we sent in a second money order for $89. And a month, about a week after I sent that, they still hadn't cashed that one. Now I got two money orders out there. So the calls started coming in from the in-house collection for DirecTV. And I started to talk to this lady, and she was very nice at first, and when she found out I wasn't going to comply with what she wanted, she started to get a little angry. She called 3 and 4 times a day, 3 or 4 days in a row. So finally, I just told her, I said, look, I told you and explained to you what happened. I am mailing something to Minnesota. I'm going to bring the copies of the money orders that DirecTV had cashed because I've already checked them out. And guess what? I'm going to bring a lawsuit against you for harassment. I slammed the phone down. Well, about a week later, we get this little paper in the mail hand-delivered by the sheriff's department. We're going to court. Now, understand this is 2006, and I really didn't know anything like I know now. So I'm kind of doing this just on the wing. And, you know, Steve, you were talking about some people, and other people have talked about things that they have found out in the past. But in 2006, I knew nothing about this. And so, you know, my wife, she looks at me and she says, I know the judge. He's got a donkey's backside, is what she said. And I said, oh, he's one of those. And she goes, yeah. And I said, okay. So I started doing some research and looking at some of the stuff that was online at the time. And I've always been an individual that was kind of cocky, kind of sarcastic at times. And we got ready to go into court. And as we walked in, of course, they took our cell phones and anything metal. And my wife asked the guard there why they're doing that. He wouldn't respond. So I looked at her and said, they don't want us recording or taking pictures of what they're doing because everything they're doing is not constitutional. And that guard looked at me and said, don't you ever say that in the courtroom. And I just kind of went on like, well, you know, didn't really understand what he meant at the time. We get in the courtroom. There's about 40, 45 people in there all sitting down. It's 8 o'clock in the morning. One at a time, they're getting called up to go see the judge. And I'm noticing that, you know, everybody is just walking up there admitting to what the judge said that they've done. They comply with what the lawyers for the other side say, and they walk out with big frowns on their face. And I'm going, I don't want to go through this. So my turn came. My wife and I walked up. And what I had read was that when you walk through that little gate, you just entered into their jurisdiction. So my wife went on through, and I just stood there. And the judge looked at me and said, are you Mr. Waters? And I said, yeah. And he said, well, you need to step forward. And I said, why? He said, you need to step forward. And I said, but I don't want to. And people were starting to chuckle and saying, I'm going to wind up in jail. And as it turns out, the bailiff came behind me and kind of nudged me through, and I went up and stood next to my wife. And I noticed that they had 2 attorneys for DirecTV over to my right side. And they were dressed in like $800, $900 three-piece suits, you know, looking all classy and stuff. And I was just beginning to learn about what people refer to as the Crown at this time. And knowing that the Bar Association did not work for the American people, that they worked for some entity outside of the American people. And you know, I'm starting to get a little brass here. And the judge started asking some questions, and I told my wife, I said, don't you say a word, not a word. And the judge started to get a little irate. So he went back to the lawyers and asked them what happened. And I said, wait a minute. There's something I need to ask here, sir. And being in the military most of my adult life, I always called people sir. It's just a polite thing and the thing that you do in the military. But I knew that the guy sitting up there wearing a black dress was not a sir. He wasn't even Your Honor. And I wasn't going to call him that, but I broke down and I called him sir. And he began to talk to these attorneys, and I said, look, there's something these guys need to show me. And they've never done that. And he said, what's that? And I said, they need to show me the contract where they bought the debt that they claim I owe, and they need to show the contract that I signed with DirecTV. And if they don't have that, by your law, I don't have to owe them. I don't have to pay them. And the judge kind of sat back in his chair, and he looked, and he said, well, do you have those? And one guy said, yes, we do. And I said, well, I would like to see it, sir. And the judge looked at me and said, I can't do that. And I said, is it going to be entered as evidence? And he said, yes. I said, then I have the right to see it. So he let me see it. Something I learned in the military about forging documents. Very simple little trick that a first grader usually does every day in school. He takes his number 2 pencil, and on the back of a piece of paper where somebody had written on it, he'll kind of take that pencil a little flatly and start going back and forth, and the letters emerge on the back side of that paper where somebody had made an indent where they wrote on the paper. So that's what I did. And the judge got irate, and I said, wait a minute, I want to find this out for myself. And it turned out to be a copy. And I said, you know, I've been reading, sir, and they can't produce the original. It's a copy, and you're not supposed to take copies. And the judge looked at me, and he began to get more irate and more irate. And finally, I looked at him, and I said, you know, I was in the military, sir, and under the military, I had to take an oath. I took it 5 times in my military life. And I know that you are an elected official. And if you are an elected official, the people don't work for you, you work for the people. Where's your oath? It should be up on this wall so everybody can see it. I know you got one, don't you? I put him on the spot. Now remember, this is 2006. Judges across America weren't operating then like they operate now. Just remember that. And I looked at him, and he got so irate with me, he said, you're about 3 seconds from being in contempt. And I said, oh, you wouldn't dare do me that favor. 3 square meals a day, clothes on my back, cable TV, internet, in the county jail. You would not do that for me, would you? He looked over at the attorney, and the attorney said, you know, he's in contempt, Your Honor. And I said, no, I'm not in contempt, because what I am is I am forcing your hand to show me you have the actual contract. Well, the judge finally had admitted that what they were doing was wrong, and they asked the attorney what they were going to do, and the attorney said, let's just drop this before it goes any further. And I said, that's good, because I was going to ask for a trial by jury. Matter of fact, when we leave here, I'm going downstairs to the first floor and filing paperwork. And the judge goes, paperwork for what? I said, I'm going to file paperwork for your violation of my civil rights. And you committed fraud against me because you and the attorney signed documentation without my knowledge. And that's called fraud and extortion. And the judge immediately dropped it and looked at me and said, I don't ever want to see you in my courtroom again. And I said, you know, you don't want to see me in your courtroom again either. And we turned around, we raced out of there. About a year later, we get another piece of paper, and it's documented by the sheriff's department. They brought it, said we owed $100 for them delivering it. And I told my wife, I said, well, you know, maybe we should deliver something to the sheriff's department and charge them $200 for it. And this one got on the docket before we were aware of, and I got a letter from the judge explaining that the case had been dropped. He did not want to see me in his courtroom because I had threatened him. Now, he didn't say that, but that's why. And again, remember, in 2006, the knowledge of what you guys have been discussing tonight wasn't there. Most people didn't know any of this kind of stuff. A few did, but most did not. Some were doing some research, and some paid the ultimate price, and some are still sitting in jail for trying methods in courts. And I have to tell you, I made mention that I'm a judge in the Republic, and we have re-inhabited the Founding Fathers' documents, and we have learned that we need to stick strictly to the judicial laws that were written from 1789 on. And there were 3 different acts that they have done, only because the country grew in bringing more states in They needed more judges, more territories, and so forth. But
what state was this on?
What I found out was that as a judge in the Republic, in the original government of this country, at the district level, a judge is only there to play referee in the courtroom to make sure everybody gets their equal shot, that procedure is taken care of and done properly. That's the only thing a judge is there for. It's the jury. It's the people that has a say. It's the people that say guilty or not guilty. It's the people who say this is what happens to him. That's the way that the Founding Fathers set this thing up. And, you know, it goes all the way down into the state level, into the local level. And what I found out from my experience was this. You don't have one judge out there in one courtroom anywhere in America that does not make 3 to 4% on court costs for his retirement fund. All you got to do is go to manta.com, look up whatever state you're in, look up whatever court or church or whatever it is that you want to look up. It's got over 1 billion businesses registered, and you'll find when that was incorporated in the state, meaning that they are a 501c or they are a corporation mandated by the state. I've looked up every judge in my county, and every single one of them are registered as its own corporation. Every single one of them is registered as making money for the courtroom. That's their main purpose. They don't do law, they do codes and statutes. For instance, did you know that last year, now Steve, you may know this, but last year they changed or amended or created 1.6 million new codes and statutes. Not all of them are for the U.S. Some of them are for different countries in the world because, well, our IRS are in their nations and we control them. But that's what their Congress did. I call them their Congress because they're not mine. I don't vote for those idiots. They got enough problems the way it is without bringing new people into the fold. And the thing I found out was, and Steve, I agree with you 100%, and I agree with the first caller too. The courts are working in no way like they're supposed to under the organic Constitution. And if we ever get the chance, then if the Republic has ever stood back up, then those court systems will work in accordance to the law and accordance to the organic Constitution. And just let me say this before I close, Randy. I saw something today that caught my eye. Now, most of us will get online and we'll look up codes and statutes and do a lot of research through Cornell University. They have that great online with, all that law stuff. Starting this semester, they are accepting terrorists named under ISIS as on their campus and studying as long as they are vaccinated. Cornell University considers being vaccinated more important on whether or not you're a terrorist or not. And we did some research on that, and what we found out was, well, ISIS is a offshoot of some other terrorist groups over in the Middle East that was all created by our own CIA. So they're recruited by us, funded by us, created by us, and now our law schools are allowing them to come in. And interestingly enough, I don't know how many Cornell has, they didn't say. But if they're doing that now, what are they going to be doing beginning in next school year? What kind of people are we going to have in this country? The judges should be dealing with things like this. The legislature should be. And yet, what they're doing is taking people like Steve and our first caller and harassing them because they're exposing truth, which always goes back to the bottom line. The enemy, Satan, the adversary, doesn't want the truth exposed. And by the way, I'll close with this. Today is March 26th, 2015. 1 year from today, 2016, we may be living a whole different life in this country. This is when Planet 7X is supposed to be passing us by. So all I can tell you is prepare and get ready. And Randy, I close.
Great, thank you. Now I wanted to jump in here and let Keith ask his question to Steve on the BOAs.
Hello?
Yes, go ahead, Keith.
Yes, I forgot one of the questions. One of the questions I have was, with the BOEs, do you send it to the regular bank or can it go to a credit union? And is there a special bank to go to? Or do you have to be a member of the bank that you take it to?
Thank you for that question, and this has come up before. All banks in the United States are Federal Reserve banks. They all carry the FDR. They are all complicit. All of our BOEs end up at the Federal Reserve Bank in New York. All of our BOEs end up at the U.S. Federal Treasury. But guess, here's a wonderful little exercise for everyone. Go put in U.S. Treasury in your web browser. The picture, the home page for the U.S. Treasury, you don't have to look very far. Maybe 2 lines down, it says, for contact to the U.S. Treasury, contact the IRS. Okay. Internal Revenue Service is the U.S. Treasury because of the 1946 Accords called the Administrative Procedures Act, where they, we've always had an Internal Revenue Service, but what we have not had was enforcement from a private enclave called the IRS. If you were to research the IRS, you're going to find their Dun and Bradstreet numbers. You're going to find their corporate app.
What happened?
Sounds like Steve got dropped off the call. I could add a little to his conversation while he's absent till he gets back. The IRS, of course, is run by the Federal Reserve Board of Governors. The Federal Reserve Board of Governors, of course, is an agency of the International Monetary Fund, and the Secretary of the Treasury is also a governor on the International Monetary Fund Board of Governors. Curiously, the Federal Reserve funds not only the Treasury, but the it's now called the Consumer Financial Protection Bureau, the Office of Thrift Supervision. So this private foreign corporation, the Federal Reserve, which are the Zionist banker cults of Europe and other locations around the world, Switzerland, some call it Switzerland, and other locations. Basel, Switzerland is one. And they basically hold control over the U.S. by the control of this fictitious monetary system called the Federal Reserve Notes. If Steve's back, chime in. Those are things that I've learned about it. I was shocked to find that the Consumer Financial Protection Bureau receives their funding directly from the Federal Reserve. I find that very troublesome since they're a central clearing point for all financial crimes, supposedly, and association with the Department of Justice, or injustice is more likely the correct terminology of it. Considering it is, in fact, a racketeering operation run by the Department of Justice, Eric Holder, they use the extortionate means of the Chicago mob model of hijacking bankers and other large whales, they sometimes call them, that they put the squeeze on, charge them a few million or a few $100 million or maybe a couple of billion for letting them off their crimes and paying for their pittance and giving them the license to go ahead and continue what they were doing until they get caught again next time. It's just the cost of doing business. If you pay millions or billions to steal trillions, it's no big deal. It's just the cost of doing business. Has Steve made it back yet?
No, go ahead.
Well, very interesting. I'll yield to somebody else. I wasn't trying to hear myself rattle, but I thought I might pick up the conversation and carry it on in Steve's absence. But these are really, really insidious things that this scurrilous, treacherous, and treasonous group has snuck in the camel's nose into the tent and basically taken over our country without our knowledge, because they've hidden in the shadows of the ignorance of the American people has been foisted upon them by their Central Soviet-style public fool school indoctrination, programming, and training facilities, and under the guise of education.
I hear water running or something.
I think that's somebody that doesn't like listening to me, so that's okay. I'll chime off.
I can't see where it's coming from.
And the last 2 or 3 weeks that I've been on, we've heard that same scratching, watery noise in the background. When somebody gets tired of listening to someone, they show their disapproval by scratching on the phone receiver. It sounds like water sometimes.
Yeah, I muted quite a few. I apologize.
I personally would like to hear more of what you're saying. I agree with you, and I can actually add more case law, but I'm not trying to hear myself either.
You have a familiar voice. Are you in the Republic too?
I am a former Chief Justice of the Nevada Republic for the Restore the Republic group, Tim Turner's group formerly. Now it's Geiger's, I think, and
correct.
Kelp Smith.
Okay, I was referring to the other voice. So you're in it too. So there's several of us from the Republic.
I'm no longer in it, but I was in it for a while. That was Roger, the other fellow who was speaking, that said he was a judge in the Republic. That's correct.
No, I know Roger's on, but there's a guy that has a younger voice that sounds very much like someone I used to listen to on the Republic.
Could have been Wayne, possibly.
I am Wayne.
My apologies. No inferences implied. Just that's a younger voice that I know from the call.
I think he's talking about Joseph. Joseph, he's talking about you, 6 or 7.
Let me take this break, if I may. This is Steve. I don't know. I was cut off in mid-sentence there.
Please continue.
We're back. I have no idea how that happened, but oh well.
We're going to take about another 15 minutes, you guys, so if we can...
Okay, Steve, you're in the process of describing the U.S. Treasury and contacting the IRS.
Thank you very much.
Yeah, right.
We have documents that have been disclosed by Rod Class and his researchers. I believe there's 2,000 researchers working with Rod Class, and he's always accepting volunteers. They were able to locate the CRIS files, the CRIS documents, which put the IRS, the courts, all together.
Could you spell that for me, please, so I know how CRIS is being spelled?
C-R-I-S, CRIS.
Okay.
I have those documents, and we'll share them. We'll put them up on our website.
Great, thank you.
You bet. There's a federal court case in Massachusetts, as I recall, that basically determined that the Federal Reserve, the courts, and the IRS are all working in tandem. Amazing document. CRIS is the
Court Registration Investment System.
Thank you very much. Boy, I'm getting tired tonight. It's been a very long day, so thank you for that.
Certainly. My pleasure.
Any help is welcome. Anyway, Chris, the documents that Rod Class and his bunch exposed is absolutely phenomenal. It basically tells us of the international private banking system who has taken over this country with use of the courts or by their deceptions. The courts are being used by the bankers to access all natural resources, including chattel being you and I. The IRS is the enforcement agency for this triad, and it's just nasty business, folks. It's really, really nasty. Between this and what Rod Class has exposed with the courts being foreign, and the Chris documents detailing who the foreign principals are, and exposing who the IRS is, and I think that's where I left off earlier, or was taken off. I don't know. The IRS has their own Dun & Bradstreet numbers. They are headquartered in Puerto Rico, along with the BLM and multiple other agencies of the federal government. Here we have the crux of the matter. We have criminal pirates. We have foreign intruders. We have these people impersonating our government. And we're all thinking, well, if I got a problem with my government, I can always just vote them out. That literally is BS. There is no voting. There's only a selection. We're presented a group of candidates, quote, end quote, to vote for. We're even asked every year, every voting year, would you retain this judge? We never had a vote on whether he was to be in office or not in Colorado. And here we're being asked if we want to retain him. We never had the right to elect him in the first place. And this is really upsetting to a lot of folks, and particularly me, when we know that the judiciary and all of their minions are not government employees. Here in Colorado, we have in our U.S. Constitution, I believe it is Article 28, Section 2, or something like that. Government officers and agents, they don't include members of the General Assembly. Neither do they include members of the judiciary. And here is what really ticks me off, folks, is that the judiciary members who have impersonated themselves as government employees, they take a check. They get paid by the state or county. Upwards of $200,000 a year for a county or district court judge. They're not even government employees. This is misappropriation of government funds, public trust funds. The bottom line here is that the CEO of our district, which is our governor, under the Vatican rules, under the Crown Templar, whatever you want to call it, he's our elected official responsible for telling us what the law is, and he's responsible for executing the law under the organic state constitution and the U.S. Constitution. Here in Colorado, we have such an impotent governor. I've challenged him many times. And all he does is take my paperwork and gives it to his legal staff. No different than the paperwork I file with my county sheriff. What do? They give it to their county attorney. Their county attorney tells the sheriff what to do. We don't have constitutional sheriffs. We have a few of them standing up. And the more we can educate, the better. Here we are having sheriffs in our local communities who have signed oaths to protect the state and U.S. constitutions, yet they violate their oaths by taking their oaths before a judge who is not a judge but an executive administrator. And the executive administrator and the county attorney are telling the judge his duties and obligations. Yet we elected him. We elected the sheriff. These county attorneys, all the way up to our state Supreme Courts, are all bar members, every last one of them. And you can follow from a municipal court all the way to the federal United States Supreme Court. It is a law within our corporation that every magistrate, every judge, all the way down to the municipal court judge, must be a member of the bar. That comes under the federal rules of civil procedure. Number 4, item J. This is where they say that they are self-appointing, self-regulating. Who's to challenge them? So why are we sitting here taking their abuse? Why do we tolerate all this garbage that they're throwing out? We are sovereign over them.
Lack of knowledge.
Lack of knowledge.
Once we gain the knowledge, there's nothing to stop us.
Steve, the article you were mentioning was Colorado Constitution, Article 29, Section 2.
Thank you.
Government employee, members of the General Assembly or public officer. It talks about public officer. Does not include member of the General Assembly or member of the judiciary.
Mm-hmm. So they're not government.
Coincidentally, Steve, we've also discovered here in Nevada, in Las Vegas in particular, that the district attorney, who is, of course, appointed by the county commission czars and paid by them, just like the sheriff is, and they have the controlling language subject to the Board of Commission czars, is how they keep their ungainful employment of egregious unjust enrichment, has apparently seized control of also the recorder's office, and now is aiding and abetting in the theft of private land from individuals here in Las Vegas by the suppression of the right to record paperwork unless you circumvent and either go to a different state or to a federal court or something of that nature. But within the county, with their little bar club of co-conspirators ruling over like a bunch of gang lords, they've seized control of that part of the government of the elected official, the high office of the recorder.
Yes, sir.
Can I ask a quick question about the recorder on that side? I have a friend of mine who absolutely will not change their status, and I don't know what other remedy to provide for them. What do you tell someone who will not change their status to the private citizen, and yet when they go to the court clerk for a civil case number, they are denied any case number, whether public or private, and when they go to the sheriff, they are denied a criminal case number? So what remedy is there other than to change one's status before doing that?
Don't cast your pearls before swine.
Well stated. Well stated.
Okay, but how do you bring your case on the military side? How do you bring your case in such a way without a number?
Well,
do you just use a registered number?
You're never going to find any remedy in those county or city or corporate courts of the states they lie within. You may find some possible remedy in other venues without those corrupt jurisdictions, although they're all corrupt from the top to the bottom, like Steve was saying. There is absolutely, unequivocally, irrefutably a bar requirement to sit on the Supreme Court. I can show you the documents from their own district court guidebooks that tell you so.
I'm interested in learning more about that. I fully agree with you already. I'm talking about a friend of mine who will not change his status.
Ignore him.
Yeah, if this friend of yours refuses to change status, that means that person of his or her own free will of choice has found some kind of comfort within the corporate structure. And you can't argue with that person. This is the very same problem that we face nationwide. Our mission here is not to save everyone. It's to inform and educate those with ears to listen and whose eyes are open. There are people we can't save out there.
Yeah.
These are drones. They're just... we can't save them all. But we can save those that mean something to us. If that person doesn't mean anything to you, I would discard that person.
There's the thing. He's a very dear friend of mine. I consider him like a brother. And it pains me that I can't just brush it off.
Let me tell you a story. I have a similar situation. I have a brother who is incorporated 32 years at it. I'm not going to bust his butt on this because he's worked very, very hard on what he has accomplished, and he receives compensation for what he has done. And I'm not going to disrupt his retirement. He is of the same mind. He says, I'm not going to give up my person because I worked for it. And I deserve to go into retirement and all the stuff that they provided me. I'm gonna spend my time fishing and doing whatever I want to do. I'm not going to bother that. And I'm not going to make him toe my line. I'm not going to have him desert what he feels in his heart was what he worked for all those years. I can't do it.
And when he loses it, Steve?
Go ahead, Charlie.
Steve,
and when
he's going to eventually lose it.
He will.
So you can educate him along the way.
Yeah.
He can grab on to the hook. As you said, he has a love for fishing. He can grab knowledge, or he can be in ignorance.
Well, because it's blood, I will throw him a life preserver any day of the week. When he discovers that he's been hoodwinked and indoctrinated and tricked and conned all of these years, I can't hold that against him because he just doesn't know. But I'm always there for him.
Until they're victimized by the system that they revere so highly and think so much of, they will never wake up. But when that system turns on them and attacks them through no fault of their own because of its consumptive nature of eating its own, and it will, he might go through life fortunate and be lucky enough that it doesn't turn on him possibly.
Okay, hold on, guys. I do want to stick something because there is a love for family and friends. And those that are truly, and I want to emphasize truly, private. If you throw them a life preserver, you're going to take yourself down. Be careful.
Not necessarily. We're here to help. We know that we stand on the ground. We stand on the land. They've been deceived.
I'm sorry. I just totally disagree with you.
Well,
so,
but you cannot violate somebody else's agency. You can share the information, but it is not your responsibility to force water down their throat. You have to allow them their agency. So,
true.
And again, if they don't grab the hook, you've provided all the information.
Once you've provided that information, the responsibility is off from your shoulders. It's now on their shoulders as to whether they want it or not.
Right, but if you are connected, it will bring down your private status.
What we lose here, status or otherwise, we are all men and women, and what we would lose in that translation, what we would lose is the compassion. This is what human beings have. We have feelings, we have emotions, we have love, we have loss, we have all of these things.
And we don't have the numbers.
If my brother was suffering just from the number, if my brother was suffering just from lack of knowledge, is that why I would leave him stranded?
If we don't have the numbers.
Oh, if we don't have the numbers to do what we are doing, and let's say the ship is moving forward, and I see a mate of mine who has, from not any fault of his own, fallen off ship, and I'm back on the stern throwing him a life raft, and still he can't reach it, and the ship is moving forward. Do I vanquish with him by jumping overboard? That's my decision, not the collective decision. I don't move forward with a crowd.
And so you drown with your brother.
If my brother were at risk, if my blood is at risk, if my legacy is at risk, I'm not going for the collective. It ain't going to happen. I will go back and rescue my blood, or I will at least give my all. That's the difference between individualism and collectivism.
Hey, Steve.
Please, go ahead.
This is Ed in Dallas.
Hi, Ed.
How are you guys?
Well,
I just got on. I haven't been listening to everything, but I did hear enough to maybe give a little bit of a heads up to everyone on a way that I learned how to turn people's head. You're talking about a situation there where, you know, you've got people that have all their life, they've been in this crazy cult. It's just a cult is really what it is. And they don't know how to escape from it. And it's the same thing with any cult, anything like that. I'll tell you the story about how I learned it. I was trying to take some people out of the Jehovah's Witness. It was actually my ex-wife. I was trying to take her out of the Jehovah's Witness, and I tried and I tried and I tried. I did everything I could do to try to show her the truth about what the falsehood was about her religion. And so what I did was, one day, I guess it was by the grace of God, that's all I can figure is the reason why I found this. But it was it took me 3.5 years to learn how to do this when I could have done it immediately if I'd understood it. But what I did was I was in a bookstore one day, and I was actually looking at some books on the subject, and I happened to come across where people that had come out of the cult said how you take people out of it, and it was very simple, very, very simple. And what it was they said that you first find out what they don't like about the cult, and then you hammer that issue over and over and over and over with whatever you can muster, whatever you can bring to the forefront to show them that, yeah, you're right. You're absolutely right. You don't try to attack anything that they're solid and hard on, in their cult system. You find the thing they don't like about it really strongly, and then that's the thing you attack. And so if you want to bring people out of this cult, which is what it is, again, that's how you do it. You have to show them, you have to find out from them what they don't like about it strongly, and you attack it in that area, and then they'll come over to your side. And I found that to be true with my ex-wife. As soon as I found out what she didn't like, and that's what I did, I just went to her and I said, what is it you don't like about the Jehovah's Witness? And she said, I don't like the excommunication teaching. And so that's what I hammered. And boy, it wasn't no time until she was out of it. So I just thought I'd drop that little hint on everybody to give you a technique to go at if you've got family members or anybody, good friends, whatever. Try that technique and see how it works. See if it doesn't work for you.
Yeah. Well, I think Charlie might have a good perspective on this. Charlie? You want to add to what you were talking about? I mean, we're all over.
No, go ahead, Steve. Go ahead.
I'll jump in. Just remember in the Bible, Lot and his wife and the daughters were leaving, and the wife turned back. We won't be able to save everyone. It's what do they want? And Noah could barely save himself, let alone his sons, and how many didn't come with, so we won't get everybody. We just have to continue with these calls and, other calls that are out there, and those that are going to have it in their heart to make a decision to learn and implement are going to be the ones, they'll be the strongest ones to survive.
Can I interject here?
Yes.
Amen.
Yep. Hello?
Come on.
Go ahead. Oh, okay. Just checking. This is Lorna in Alaska. And Randy, I couldn't confirm what you said. There's just no way to confirm it more than 100%, but if I could, I would. He said very clearly, Yahushua HaMashiach said, even in his day to the people that he spoke to, that I come not but to save the lost sheep of the house of Israel. Not everyone will come.
And unfortunately, some of that will be our loved ones. It says when there's two in the field, one will go, one will be taken. That means 50% isn't going to make it, isn't going to do it. And
what kills me is that this is a messianic doctor.
Let me finish, please. I have 4 sons. I look at those numbers, and I think, wow, So I do my best to train and teach and talk, and that's all that can be asked of us, is to do as much as we possibly can. Whoever that was, you may now talk. Go ahead.
I was just saying that this is a messianic pastor. Who else are we going to get except for someone like that? Anyways, I'm not really trying to turn it into a spiritual dialogue. I just was trying to ask if there was any other remedy beyond status correction that might work for him.
Under the circumstances, it is a spiritual battle precisely. It's the battle between the sons of light and the sons of dark.
I agree with you. I was just looking for any other remedy because I clearly can't convince him or persuade him, and it pains me that I can't because I fully agree with you.
You have to allow free agency, and Jesus Christ himself said that my sheep will hear my voice, implying that there are those who won't.
Right.
And it's also a matter of timing. Sometimes, he might get it, but it might take him another year or two. Timing has a lot to do with life, too.
Yeah, sure.
Thank you.
Thank
you for this.
I have a law question.
Have a what?
A law question. Since we have so many wise, learned people on this call, I might throw it out here and see what they think.
Okay.
I'm in Federal Rules of Civil Procedure, Rule 15, which is amended and supplemental pleadings. And you have a time window open, 21 days from the original filing of your complaint, where you can file a First Amendment to your complaint without leave of the court or your opposing counsel. But then there's a couple of other things that operate on that has to do with the 12B motions back and forth to try to invalidate your claim, then you trying to resubstantiate your claim and look for substantial justice and meaningful opportunity to have your case heard on the merits. And then the opposition will then try to oppose your opposition to their opposition. And so I think each one of those tends to keep that window open for that original First Amended complaint filing without leave of the court. And what 15B says is if the pleading is one to which a responsive pleading is required 21 days after service of the responsive pleading or 21 days after service of the motion under 12B, C, or F, which is earlier. It says in all other cases, you would have to have leave of the court or your opposing counsel. But within that specific exclusionary exception of while it's in the original pre-trial motions and pleadings phase, there is a time window of when you can uncontested file your amended complaint, which I have a rather extravagant one. I'm wanting to womp on them. That's why I was kind of looking for some other wise heads' interpretation, if they have any knowledge to speak to that they might clear up if I'm misunderstanding that. But I think that's the way I read it, so I'm kind of curious how others perceive it.
Chris, why do we have to go under FRCB?
You don't. My answer, if I may, whenever we consent to anything these courts are doing, we are obligating ourselves to their timelines. And there is nothing more abhorrent than having to respond to something without proper preparation, without proper defense. These courts never allow proper defense to answer to due process procedures that they've set. Due process should be unlimited. In other words, it should account for all of the defendant's rights. Well, I'm illiterate. I've got to learn how to read first before I can respond.
Oh, I agree, and I claim ADA protections also.
Yeah.
Okay.
We're being asked to respond in their language, and yet they're going to penalize us for not knowing their language, and they do all the time.
Oh, habitually.
Habitually. So the game is rigged in the beginning. So what that does is create fraud, inducement, threats.
Which Rod Class revealed.
Exactly. Thank you, Charlie. And he did so eloquently.
So we should not be. Should we be doing like Rod Class did and reveal the fact that there is a fraud and they are not obeying their own rules? No.
At every level.
I have a
we
friend.
Should not be doing that.
I have a friend
Rod
by the name of...
sent in a private side. That's why he is authorized representative.
I have a friend who got a bar registrant disbarred, and he says the way to do it is you go back to the bar's rules, and then you expose them for violating their own rules.
3 grievances.
Yep, there you go.
Yeah, that's Judicial Discipline Commission. They're part of the bar.
Okay, then
it's a box
find out,
the hen house.
Figure out how the bar registrants are violating their own rules.
And to whom to report the violations to is important.
Yeah.
We know, just like Charlie was indicating, the Colorado Judicial Review Committee, it's a worthless can of crap.
It's a joke.
It's a joke. Walter Campbell sits as a judge. Oh, excuse me. Yeah. He sits as a judge for all of those protests and arguments and challenges. He sits as a judge himself, and he is not regulated by anybody but himself. And
he claims that writ of habeas is not a worthy motion.
Yeah.
Or
so he's a judge of all of our challenges. Come on. He's just one man, and he's a stupid man. I've had umpteen dozen challenges up before him within the last 3 years. He rejects all of mine, and I take that as an admission of his guilt for not knowing shit.
God, we should compare, Steve, because I've got some good ones.
Oh, okay. if we were to launch an assault, it would be against that man right there, and we would take it all the way to the.
Hello.
He's a dweeb.
Yeah.
Now go ahead, Keith.
I still didn't get my questions answered. My question was, can you issue the BOE to a bank and a credit union? And do you have to be a member of the bank that you submit the BOE to?
You know, I do apologize to you, sir, because we did not give you a full answer, and I was very remiss. We just jumped completely off the subject somehow. Here is the answers. You would file your BOEs with a bank. I believe I answered part of it because all banks are Federal Reserve in this country. What you can do is file with the U.S. Department of Treasury, and better yet, you file your BOEs with the CEO of the corporation, and this would be the Pope and the Vatican. And I've actually sent stuff over there. I haven't heard anything back yet, but we know that that is the process by which you do this. Bills of exchange with being loaded with defiled, defrauded oaths of office need to be filed, as Rod Class indicated in his Quorum Nobis, need to be filed with the CEO of the corporation, and we know that to be the Pope or the governor. So you file with the governor your BOE. He's put on notice as a district governor, and then you file with the Crown Templar, which is the Bank of London, and you can send a copy to the Pope. I have that address if you would like it. I've sent stuff over there already. And you can imagine how many BOEs or complaints that they have to run through worldwide. It's enormous. They're just having an avalanche of this shit. So, to answer your question directly, you do have recourse, and you need to file these with our own United States Treasury, which is, as I mentioned, orchestrated by the Internal Revenue Service. Go to the U.S. Treasury website, and you are immediately connected with the Internal Revenue Service. That's who's taken over. So you put them on notice. You put the governor of Colorado or governor of your state on notice, as in a mandamus. They're responsible for everything in their district. And then you take it all the way up to the CEO. If there's no remedy there, sir, I don't know. Frankly, I don't know what to do.
Steve, about a year ago, I remember receiving notice that the Pope has issued notice that he will not be responsible for anything anymore that the bar registrants do. So
that was
I don't know how this is going to play.
As of September 1.
I think it's called denial, but
that was officially brought about on September 1 of 2013. It's called motu proprio.
Right. Yeah, that would be about right.
Yep. And the Pope ordered them to get it right or get the hell out of town, didn't he?
Something like that, yeah.
They will.
And how much time did he give them?
3 years.
What? No. 3 months, and he gave it initially on July, and the 90 days took effect on 1 September of 2013.
Well, I guess I may be mistaken here, but I thought it was a 3-year time period to either clean up your act or get the hell out of town.
No, I think it was 3 months.
Am I wrong?
I think it was 3 months.
It was 3 months. I can send you the link if you wish.
Oh, please do.
Okay, and so since they didn't clean up their act and get out of town, now what?
Well, the Pope The Pope has complete control over everything, apparently, over his corporate world, his new world, whatever. The bar, okay.
Let's send them on a cruise.
Yeah, since they love maritime.
I've been told that the art of diplomacy is knowing how to tell somebody to go to hell and have them look forward to the trip. Well, the Pope, you know.
Oh, my. Yeah, thank you. The Black Flag Brigade is giving them a lot of advanced warning.
Who?
Black Flag Brigade. That's what we call ourselves here.
Oh, okay.
And I believe Mr. Rice is on there. He can describe to you what black flies do.
Oh, yeah. Nobody wants to experience it. If you have experienced it, once is enough. But if you've ever been attacked by a horde of biting black flies, the only place you can get away from them is in the water. And it'll absolutely drive you mad. And even when you come out of the water, they'll attack whatever's out of the water. So, yeah. So that's what I want to do. Is I want to see if we can find a couple of rusted out oil tankers, give them about a quarter tank of fuel, and load up all these bar members and wish them a bon voyage.
Why won't we throw them in Fukushima instead?
Right.
Well, got a question.
Guys, we forget the Vatican has their own court. Do we stand a chance?
Of course we do.
Got a question. I've got, on one of my cases, I have an attorney who was a junior prosecutor. I think, I can't remember the proper term, but he was a junior anyway. And he was fired because of what he did on my case. And I have sent him a lawful notification letter. And a few days later, he disappeared. And so I'm just wondering, does anybody know how to chase his character down?
Send me his name.
His name is Jason Larimer.
No. If you can't, just put it in an email, and
Okay.
I'll go look it up.
I can do that.
Yeah,
the bar. I contacted the Oregon bar, and they have no record of him. He's not current anymore.
Well, send me his approximate age and where he was last.
Okay.
If you got those,
Sure.
and then his first and last name, and if there's anything out there, I'll be able to pull something up.
Okay, thank you. Thank you, Randy.
Randy, also for bar numbers, the state Supreme Court.
Okay.
Okay, if you put that in, you can find the history.
Okay.
I sure hate to exclude him.
Yeah, and by the way, I didn't mean to laugh and chuckle, but
Why not?
It did crack me up.
Why not?
He's now disappeared. Nothing would please me more than all these bar attorneys and judges kind of disappearing.
Yeah, I thought it was kind of a comical, except for now, where do I get a hold of him? I don't want to exclude him. I want him to have some of the fun.
Supreme Court. Hold your Supreme Court.
Okay.
Accountable. Come on, people.
There you go.
Well, it takes education to do that. If you don't have the education, you're powerless. So, I'm learning.
Well, Charlie brings up a very interesting point. And any filings of a BOE, a copy of them should go to the clerk of the U.S. Supreme Court. The clerk has more power than you people might understand, might recognize. The clerk is responsible for the conveyance of any and all paperwork to or from the Supreme Court justices. So, if she does not do her duty, and this applies to all clerks of the court, you can actually write them into your 15 USC 1 for failure of to do their contractual duties. And she's facing 10 years and a $100 million fine. And this is well above statutory law. A clerk of the court is an officer of the court. And
they are the court.
They are. No, hang on. No officer of the court is the court. And that was proven out by several case things. And I've got the stuff on that. A judge is not the court. Do you understand? When we go to court, we're going into a game. Think of a tennis match. Where's the judge? The court is is where the game is played. Who is the judge? The judge is sitting up there on this, 8-foot pedestal, and he's looking at the ball going to and fro. That's the judge. He is not the court.
But the court actually should be the jury, as my understanding.
Thank you very much, and that leads way back to Dr. Livingston's talk earlier. The jury is the audience, are they not?
Yep.
Hey, wait a minute.
They're the people.
The people. The people who are observing the court. And that's what every one of us on the call are. We're observers of the court. We have the obligation and duty to report what we see. And what we see and report is our indictment or non-indictment. I don't see any penalty over there, but I do see something over here. We are the court. This is what has been lagging and languishing, and it's what's being ignored. We are the court. And as the court, we can publish our indictments. We can say, that's wrong. And we have the obligation and duty to publish it anywhere and everywhere that we see wrongdoing. It is in the publishing. Please, go ahead, Charlie.
Okay. Dr. Livingston was brilliant, like you said. He mentioned the term assize. Mm-hmm. Essentially, assize, in my evaluation, is the grand jury. And whoever chimed in again just before you spoke, they were talking about the jury.
Absolutely.
It's the people.
We are the people.
So if we, the people, want to take control, just as Anthony Williams has mentioned about the common law grand jury, and we that believe in the common law grand jury, we the people must assize.
You bring up an excellent. You bring up an excellent point, and I saw a newsreel from Florida mainstream media, Channel 5 or Channel 7 or something.
Channel 7.
Okay, they were interviewing Anthony Williams, and he was brilliant in his response. This reporter was asking, well, where does this common law grand jury meet? Oh, whenever, wherever. Do they meet somewhere? Yeah, somewhere.
Thank you. Thank you for bringing that up, Steve, because, again, I got a personal email, and Anthony basically said the reporter basically, just went all over the place. She did not report the facts.
She did not, no.
Steve and Charlie, I had the occasion to speak with Anthony Williams and one of his protégés down there about 2 weeks ago. He was heading out of town, probably to that Florida situation whenever I spoke to him. But They're very good guys, very sharp guys, and I admire the way they handle themselves and present themselves. It's very astute, and he didn't let that reporter, which was likely a COINTELPRO agent or undercover cop, elicit all the information they were trying to get from him. I thought that was rather clever.
It's not over. The fat lady has not sung.
That is right.
I was very pleased, and I do need to make a retraction here. A couple of weeks ago, I had mentioned that, well, Mr. Anthony has not shown me that he is what he says he is, and I was basing my feelings or my opinions on what I saw on his website, and I think that was a little bit short-sighted of me, so I do apologize.
He's not an attorney.
He is not an attorney, no, and I recognize that fact, and I do apologize for any insertion that or assertion that I made.
He is a PAG under 42, 90 to 88.
Yes, he is. He's just like me. He's just like Chris. He's just
You're a
like...
PAG.
I am a PAG. With one exception, I don't have a badge. I don't need a badge. It would be really cool to have one.
You know, anybody can be one, though. You don't need. You can go buy a trinket and have a special, a little piece of plastic or metal. But any one of the people who is not a member of the public with a bond can be a PAC, and you don't need to be anything more than a regular, whether you're going to call it PAC or other, just a prosecutor, a man and a prosecutor. It's all required.
It is.
Bingo.
Generally, agree with
some people, some on the call don't know what that stands for, Private Attorney General. And I know there's a website out there to study that pretty heavily. What is it? I know it's been thrown out here a few times.
All you have to do is put in PAG, and you're going to find numerous PAGs all throughout the country.
Anyone more better than the other?
Thank you, Randy, because I thought he was saying PACK.
Yeah. Oh. No, I knew I needed to clarify that. Go ahead.
Provision for the Private Attorney General's office or role, if you will, comes from the power of Congress extended to their public policy acts, which are a limited area that we're authorized to act in to preserve, guard, protect, defend, and secure the rights of the least sophisticated from being preyed upon by agents and actors acting outside scope, sphere, and color of law. And in the title, in the FDCPA language of Congress, it says that the primary means of enforcement is through the aggrieved consumers, victims, who take up the role as prosecutor under the Private Attorney General mechanism. And so,
Chris, respectfully, it's Charlie. That's the de facto.
Well, what Chris is doing is identifying what the public at large looks at a PAG as. So,
yeah, I don't argue
but
that
under 42, 1988.
Yes, but it actually comes from the Judiciary Act of 1789, and then the amendments there too. It's also incorporated in the 1976 Attorney Fees Awards Act, the 1964 Civil Rights Act, and other public policy acts of Congress carried out whereby it's used as the enforcement means by the aggrieved parties or their advocates.
I need to share something. When I thought it was PACK, PAC, I thought that's what you guys were saying. The first immediate impression that came to my mind was a pack of wolves.
It's PAGs, darling. It's private Attorney General.
Okay.
If we were all to get together, if all the PACs were to get together, there would be no judge standing in this country.
Very true. All right, you guys, 4 minutes, and then we're gonna bring it to a halt. So, anybody with their parting words?
Yeah, I have a question.
Yes, the question.
Yes. Since there are so many schools of thought, I was wondering if everybody could take one or two sentences and say if they have any kind of cure, quote-unquote, cure for child support.
I do.
Go ahead.
In 4 words, if I may.
Mm-hmm.
And go to our website at Four Corners Doctrine, WordPress.com.
Mm-hmm.
You're going to find a preliminary diagram with 4 words on it. And those 4 words are jurisdiction, presumption, injury,
okay.
and consent.
Okay.
You do not consent. They operate by voluntary consent, whether you know it or not. And there's a place called the FamilyRightsCenter.com that has a document called TPS Violates These in Every Case. And it has a long list of almost every civil rights violation known to man that they habitually violate. They never have warrants, never have probable cause, hardly ever have exigent circumstances. But most people don't know their rights, therefore they don't have any rights.
Mm-hmm.
And Randy, my injection is go to what our class, Rebecca Cope, et al. Are doing.
I'm sorry, you're
Rebecca
echoing.
Cope?
I didn't.
Yeah, it didn't come through totally clear. Was it Rod Class?
Okay. Rod Class, Rebecca Cope, sovereignty for, I'm sorry, I can't remember the website, but essentially the International Tribunal.
International Tribunal of Natural Justice.
Thank you, Steve.
You're welcome.
Okay, thank you.
I would say this, though, folks, with Rod Glass, one of the things that he's doing wrong, and I've tried to explain it to him, that's why the D.C. court said that his stuff was unintelligible, is that he's mixing his law. He mixes the organic law with the 14th Amendment law. So, but don't do that. You either go 14th Amendment all the way.
Rod apparently submitted his documents to become private.
Yeah, but I read his documents, and his documents were mixed, and I got suspicious as to why they were saying that his stuff was unintelligible, and I read his documents, and I know why, because he was mixing the organic law with 14th Amendment law.
So why was the response from the court? Is he the authorized representative?
How is it wrong to use 14th Amendment law to hold the federal agents accountable?
No, they already recognized he is the authorized representative.
I will
You
agree
can do
with
that.
the
You
first.
can do that, but that's what I'm saying. Either go one way all the way, but don't mix the two. He's going back and picking up the original organic statutes at large and putting that in with his 14th Amendment stuff under the United States Code annotated. That's all 14th Amendment, every bit of it. Everything's 14th Amendment.
Probably what he did was he's using 14th Amendment, which means he's declaring himself the capitalized name is a U.S. citizen, and yet he's coming with the common law and constitutional given rights, which is that's American national. So you can't be an American national and U.S. citizen at the same time.
Exactly. That's what I'm saying. That's what makes it unintelligible.
Exactly. So he doesn't
Gloria,
understand.
thank you. 14th Amendment, Section 3.
I will agree with the questioner, and I have taken his document, the Coram Nobis, and I have addressed that very problem. I don't know, though. I believe Rod Class may be using this as cross propaganda to the courts.
Well, I'll say this, what you can do, Steve, what you can do, and this is what I do. When I do my stuff, I will use organic law, but what I do is I'll say, even in the 14th Amendment, or even in the color of law, that's really what it is. Even under color of law, it says blah, 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 but I just use that as a second witness. I don't rely on both at the same time, because it doesn't make any sense. You know, you're talking about two completely different realms of law.
Yes, you are.
Sir, so you are going under 14th Amendment, Section 3.
We are, and so is Rod Class. Here's the argument. Here is what Rod Class is doing. He's using a psychology that is unknown to a lot of us, and purely unknown to the courts. What he's making them do is to say, well, this is unintelligible. What he's trying to say of the court is they are unintelligent.
Exactly.
And that is the play. It's no different from us filing an affidavit of truth with all of these questions. Well, do you, sir, believe in this? Do you believe in that? Yes or no? Is this correct? Is the 11th Amendment correct? What is your opinion of the 11th Amendment? This is Rod Class's game, and he's playing it very well, by the way.
So, the thing is, though, he declares that all the courts are foreign from the American state in union.
Yeah.
And so basically then he has to play that game, whether if he's a foreign, then he really cannot communicate to the court directly. It has to go to the Secretary of State on the Foreign Sovereign Immunity Act on a Title 28, Section 1603 to 1608.
Correct.
So, yeah, so then he's mixing all kinds of stuff, and I don't think he truly understands. He has to either stay as American national and play that foreign sovereign immunity, or you got to stick to the U.S. citizen side on the Trading the Enemy Act and say, hey, my security is transfer, and now, any aliens or residents, that has to be charged. So you have to be on that side, or you have to be on this side.
You are correct. You can make a wonderful assumption, but here is the genius of Rod Class. What he put into the court, he got an answer to, and I think I alluded to this earlier in the call, because, or another call, I forget. Anyway, he got a letter from his prosecuting U.S. Attorney General, and the letter was very succinct, and it asked him one question. Are you representing the defendant? Are you, Rod Class, representing the defendant? That was all Rod Class needed to hear, because what it did was set the stage, the theater action, the entire theater production, to where Rod Class, he's sitting out there as the audience, and his performing piece, Rod Class uppercase, was on the stage with this court. And the court can only entertain what they have contemplated. They can only entertain what their fiction is. These courts only write fiction. The lawyers, the legislator, all of these people, all they can write is fiction because they have none other. So for the U.S. Attorney General to write him a question, are you representing the defendant, was all Rod Class needed to hear as the orchestrator for this event. Rod Class sat back there as the, I used to work for several of them. the production executive. He used to sit back in the audience and say, "This is what I want. That's what I want." Rod Class has them acting for him. And all he's got to say is, yeah, I'm the authorized agent. I'm the administrator for what you see on the stage. I have him masked as a defendant. You got a problem with that? That's the brilliance of Rod Class.
Can I interject a quick question that you could have asked if you were Rod?
Oh, sure.
By what law, right, or authority do you accuse me of being a you?
There you go. That's it. That's what Rod Class has done.
Steve, I have
and
a
he
question
produced
for you.
that in the Quorum Nobis, didn't he?
I don't know. I haven't read that.
Oh, it's a beautiful document. By what authority are you challenging me? I'm the producer of this film. You're just an actor, and you've already told me that you're an actor. And by golly, you're a foreign actor. You know, we can fire you. We can let you go, and we'll get an Italian in here instead of you British. Or if you think you're French, we'll get somebody from Switzerland.
Well, I got a question about that Quorum Nobis.
Please.
Go ahead and ask it. Final question.
Okay, and I need your contact information, Steve.
Okay.
I don't know if you caught that, Steve, but I need your contact information as well.
Sure.
They're using federal rules in this, and I'm in state court. So how is that? How are they going to relate that? Because they don't listen to anything anyway.
All state courts are federal.
I understand that, but they don't understand.
No, you're not understanding it. If you're not accepting it, you need to go.
Well, I'm accepting it, yeah, but they're not. That's the problem.
The state court has adopted some of the federal rules. If you'll go look that up on the internet, you'll find that they have adopted some of the federal rules. See, so that gives them the right to do that.
Well, let's cut this short, Steve. I just need some contact information for you, or if I can give you mine real quick.
And I didn't mean to reply belligerently.
I understand. And we're short of time, and I can't find anything on your website so I can contact you.
Oh, sure. CL West Slope. That's Charlie Lima. Whiskey. Echo. Sierra. What's T? I forgot what
Tango.
CL.
Tango.
Wait a minute.
CL West Slope.
West
Slope.
Sierra, Lima, Oscar, Papa, Echo.
Don't do that to me, okay? Because I'm hard of hearing, and you all are echoing. CL West what?
Slope. SLOPE.
Thank you very
slope
much.
on a hill.
There you go. Slope.
That's it. At gmail.com.
At Gmail. Okay. I really appreciate that. I'll be in contact with you for, I'm going to put this into the court tomorrow. I'm going to be working on it tonight.
You bet. Let us help you.
This is some actually asked for having a remedy and not having a citizenship, right? American citizenship. Basically, you can look at this video. This is actually for everyone. You could win the case if you understand this video. This video is made by Richard Comfort. And if you go to YouTube, Secrets of the Legal Industry. Secrets of the Legal Industry. He has a wonderful video that will explain, and anyone could win if you understand what he's talking about.
Very good.
I'll back that up. I've seen it. It's good.
And Jim, I just forwarded both of your emails over to those parties that you were requesting.
Thank you very much.
Yes, they both have your info right now.
I appreciate that.
So everyone check your inbox, because there's two of you that just got an email from me.
I have one final comment, and that
last one. Thank you.
thank you, everybody, for all of your participation. I
Yes,
enjoyed
and
it.
actually, I'm going to unmute one person real quick. Okay, go ahead, Dave.
I was on a call last night, and a fellow who has been dealing with traffic laws for the past 20 years, Shard, Blackstone, what he said specifically that was very, very on point was blowing smoke. More paper is more than blowing smoke. You get more energy with paper than blowing gas. Blowing gas is nothing but your lips flopping in front, in a court, not knowing what you're talking about, but submit it on the paper, put it on the record, and now that speaks for yourself. So the more paperwork you file, the ways come down. The laws of justice, the scales. The more paper you got, the more opportunity you have to win. As long as everything's based on fact and what you're saying. That's all.
Okay, can I put one in for Hartford on that very subject? He has everything. Everything is documented, and everything. It says that all rebuttals have to, and this is paperwork that he submits to them. All rebuttals have to be in writing, S&S, in truth, in fact, and have to have proof of the objection. So everything is pinned down to where the lawyers, the other guys, cannot wiggle at all, and it all has to be done in writing, and they have to provide proof of the rebuttal, or proof of the objection, the object of the rebuttal.
Excellent.
Trinzi versus Pagliaro.
Right, and that way, when he goes into court, or if whoever goes into court, and the judge asks you, this question or that question, you just simply say, "I have nothing to say. It's all right there in the writing."
And I've got one thing real quick, see if I can find it. Somebody had a request for a case. I think it was, I don't have it up anymore, but I think it was the People versus Sajak. If anybody has it, please send me a copy or a link.
That's the paperwork. Judge is not the court, I believe.
Yep, it is.
I didn't hear it. It's the paperwork that what?
A judge is not the court. That's the doc.
Okay, a judge is.
And Randy, it's in my paperwork.
Judge is officer of the court.
Okay.
Randy,
right,
I'll pull and email it to you right now.
Great, thank you.
Yeah.
Okay, great call. I think you guys all know that. Thank you all for your participation, and the guest speakers, and then those that ended up piping in that were so educated. Thanks so much. We love it. Next week, I'm sure it's going to be just as jam-packed. Don't miss our calls. Spread the word. Follow us on Facebook. Follow us on Twitter. If you need me for anything, support at 42 Action. I put you in touch with whoever you need to be in touch with. And it's 12:30 here on the East Coast, so I am going to sign off and head to bed. Good night, everyone.
Thank you, Randy.
Thank you, Randy. Thank you, Steve. Thank you, everybody.
Thank you all. Yes.
Mm-hmm. Bye.